You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is Waterhouse versus the state of Florida.
Good morning. Bob Norder on behalf of Robert Waterhouse. I've reserved 3 minutes for rebuttal. The first thing that I want to talk about is the first issue in our brief, which has to do with the destruction of evidence. And I am coming before this court, understanding that there is the case law in Arizona versus Youngblood, but I think that this court is presented with a unique situation where someone who will be executed in 8 days had significant evidence in his case that could have been DNA tested, destroyed through what I think is recklessness, negligence, however you want to characterize it, by the clerk of court.
Didn't we have that issue before us about 8 or 9 years ago when a claim was made for DNA testing?
Yes, ma'am. And in that case, the issue was Mr. Waterhouse entitled to a new trial based on simply the due process clause related to whether or not that case, the destruction of evidence in this case was so egregious that it met the criteria of getting around Arizona versus Youngblood. And,
So help me understand what has changed in terms of both the evaluation of the evidence against your client as well as the law that would warrant us to revisit an issue that was raised almost in this precise way.
Well, like I said, I'm presenting this to this court in what I feel is a unique posture. I think when somebody is actually about to be executed, and you guys can disagree with me, obviously.
Well, you're making a variation. Your position is it's not the same argument.
I think that it's a totally...
not for a new trial, but that this should prohibit the application of the death penalty is what you're saying.
Yes, exactly.
Yeah.
And I think this is a unique situation. By law, evidence in a capital case should not be destroyed. Mr. Waterhouse availed himself of Rule 3.853.
Well, I think that the state agreed, everyone agreed that the evidence shouldn't have been destroyed. It was, that there was no evidence it was done in anything other than, whatever we call it, careless, negligent. But you've said that you're asserting a claim that Mr. Waterhouse is innocent of this crime. And that's where I've got some problems. I mean, if we were here in a case where there were serious questions about his innocence, maybe it would be a different posture because I understand that this is the ultimate penalty. But the evidence against him really hasn't changed over the last 32 years.
Well, I think that's, I don't want to belabor this particular issue. I mean, you're either going to look at this and say, as a court, there's something wrong with executing somebody or the key evidence in some of the key evidence in their case has been destroyed, and cite constitutional provisions to back that up. But your comments about the weight of the evidence in this case, I think, gets immediately into the second issue presented for this court, and I respectfully disagree with you as to the strength of the evidence against Mr. Waterhouse. The second issue in this case involves a claim of newly discovered evidence where an additional witness came forward upon reading about this impending execution, read it in the Tampa Bay Times, came forward, saw a statement in that article that Mr. Waterhouse was seen by witnesses leaving the bar with the victim. He came forward and said, no, that's not true. I saw him leave with 2 males. He didn't leave with the victim.
But can we sort of look at the whole transcript, do we not, as we look at the evaluation of this different evidence?
Yes.
We must look at the entire trial. And in going through that, I mean, even again yesterday, it seems to me that the witness Vasquez also said that he left with 2 men, correct?
Correct.
But Vasquez also puts him back at the lounge after leaving with those 2 men in the vehicle that came back to the lounge, did he not?
But then also saw him leaving again.
No, I don't think Vasquez.
Yes.
Vasquez saw him leaving again with
Yes,
whom?
sir. Yes, sir. He dropped off one individual named Spitzik, who was the alleged drug dealer.
Where in the record is that? Because I'm sorry, I don't read the record in that fashion. Could you help me with that then? Is that in your brief specifically?
What I'll do is I have co-counsel.
Okay,
I'll have her look for that
That's fine.
portion in the record. But my recollection is that Mr. Vasquez saw him return to the lounge,
right,
but then drop off the one individual and then leave. And he talked about the one individual, Mr. Spitzik, coming in, buying some drinks, hanging around, but that Waterhouse had left. And so I mean, that's in the record, so, I mean, I can't answer that off the top of my head right here.
I understand. It was my understanding, though, that, and I can tell you, I mean, to me, this is maybe an important piece. The Vasquez saw him come back into the parking lot area, and I don't know that does he address whether he's inside the bar again? And then sees him?
Actually, since these record pages are numbered so poorly,
right.
It's at bold print 3805, or the original was 1943. He talks about on that page when they came back, he then says Waterhouse and his friend continued on in his car.
Okay.
And so, you know, clearly the evidence of Mr. Waterhouse, there was a bartender by the name of Kyojin who claimed that she saw Mr. Waterhouse socializing with the victim, leave the bar with the victim. Mr. Vasquez contradicted that, but
but that's not necessarily contradictory, because the times here are unclear and people are coming and going, and there are things that can be seen from one part of the bar that cannot be seen from another part of the bar. Isn't that correct?
Well, I think you have to look at the big picture. Ms. Jin was fairly certain in her testimony as to the time. She had Mr. Waterhouse sitting with the woman for half an hour, had them leaving together at a very specific time. When you look at the testimony of Mr. Vasquez, when Mr. Waterhouse left, he never went back in the bar. As Judge Lewis's question, and we were able to cite that in the record, when Waterhouse did come back, he drove off, and this was late in the evening. There was no evidence. I mean, the state has a burden of proof beyond a reasonable doubt, and if you start to speculate, well, yes, they impeached Miss Jin, but and maybe she was wrong, and maybe he somehow hooked up with her under other circumstances, that's pure speculation. That doesn't put him with the alleged victim.
But the newly discovered evidence, I'm glad that the judge granted an evidentiary hearing, so we're not either speculating about what Sotolongo, who comes with his testimony 32 years after the murder, and the judge made a finding of credibility that his statements about what he thinks he saw that evening were not credible. Now, was that credibility determination made by the judge?
Well, I think we have to look at the nuances of what Judge Beach found. He found his testimony was material, and he didn't completely discount it.
But yes, that's correct.
But he simply looked at, as far as the Brady claim, he didn't feel that the police officer misrepresented the evidence, but he did find that Sotolongo's testimony was material.
So if you, under Jones, we take this as newly discovered evidence, then what is the standard you have to meet in order to avoid the death sentence in this case?
Well, I mean, clearly we have to show it's newly discovered evidence, which I feel is obvious. Number two, we have to show that it would likely produce an acquittal at trial,
all right,
at
now,
retrial.
Isn't that where we're really talking about that as far as there's nothing that has happened in 32 years that's changed the bartender's testimony? Vasquez did testify at the original case, and the defense lawyer had a chance to present that. But we also have what has come out of Waterhouse's own statements to the police in a series of whether you call them confessions, but essentially where he admitted that what happened was he was having sex with her, and then he sort of went crazy. And I mean, that's not changed, or now are we saying that those statements are really not what happened?
Well, I think if you actually, I think there's two different sets of statements attributed to Waterhouse, those to law enforcement and those to one of the jailhouse snitches in this case. And if you actually read the statements versus what they've become characterized through the 32 years this case has been around, when you actually read the statements, they are very equivocal. They are not any type of direct admission. They can be subject to many different interpretations. The testimony.
Well, let's start with the one. Did he know her? he first said he didn't know her, and then he admitted he knew her and knew her for several months. Waterhouse was not anybody that was a stranger to the bar. He was a regular there. So we start with the fact that there was opportunity and that she was at the bar that night. He knew her, and that's so. Is that correct, that they knew each other, or he knew her?
Right, but you know, somebody like Mr. Waterhouse with his background, picked up by the police as a suspect in a murder case, initially denying who the victim is, and then later saying, yeah, I really do know her. I mean, does that...
All right, so we start with no,
does that wipe out his presumption of innocence?
Not alone. And then what does he say about his sexual act with the victim? What does he say?
He didn't admit to a sexual act with the victim. He talked about some nebulous woman, did not admit it was the victim. That he never admitted on the night of the incident having sex with this specific woman. I mean, it's almost like, you know, when you look at the jailhouse snitch Young, that even in this court's opinions has been characterized as him admitting to putting a Coke bottle in the victim's anus. That's not what Mr. Young's testimony said. He made some nebulous comment about, I will stick a Coke bottle in you like her. We have no idea in the context of that event who he was talking about, what female he was talking about. There was testimony that he enjoyed consensual rough sex with women.
Well, I guess
we have no idea what he was talking about.
But I guess what we're talking about here, because this is now a newly discovered evidence claim, is whether the nature of Sotolongo's testimony is such that it would probably produce an acquittal at trial. In that sense, we do look at all the other evidence. Now, individually, and we must look at the blood that is found in Mr. Waterhouse's vehicle, whether that there's blood there. I mean, you may say, well, maybe it wasn't the victim's blood, but there's blood all inside his vehicle, correct?
There's blood in his vehicle, correct.
Right, a lot of blood.
Blood that we could not test in DNA testing.
Well, you didn't. The first time someone tried to test it, I mean, it wasn't contested at the time of trial that it was consistent with the victim's blood, was it?
Correct, but this was before DNA testing, when they simply could do ABO testing and enzymes, and it was consistent with
So are we saying
millions.
that maybe he killed somebody else in his car? And
I don't think it necessarily had to kill somebody else.
It was. Did he say it was an animal, that he had an animal in his car? I mean, it was blood indicative of a violent struggle in his vehicle.
Not knowing whose blood that is, I mean, I can't sit here and tell you what my client's, explanation was. I know that there was some investigation in this case that he and his friends used to get into bar fights and would get injured and would bleed in the car.
Has he ever taken this, speaking of what your client says, has he ever taken the stand and said, I am innocent of this?
He's not. I mean, he's only had one opportunity to do that, and that would have been in the original trial.
Well, but I'm just saying, so not in the post-conviction when there was attacks on the performance of his counsel?
He did not testify at his post-conviction hearing. He did sign a sworn motion asserting his innocence when we asked for the post-conviction DNA testing. But when you look at the statements to the police, I mean, you can draw conclusions from them, but the bottom line is they're equivocal and open to different interpretations. His statement to the jailhouse snitch is equivocal, open to other interpretations, and the jailhouse snitch didn't get suppressed by deals, impeached by deals he was offered, because that was suppressed initially, and that was deemed to be harmless error in his first post-conviction appeal. Yet that person had been offered deals and wasn't impeached by it, but even his statements are equivocal.
Well, what kind of light do you place on the discussion of her current or physical condition that evening, and his distaste, and then the way she was found, and then all of that? That doesn't seem as though it's just coincidental, does it?
Well, by the time that he was questioned by the police, you have to, and we're dealing with a record that, I mean, the trial was the trial. I mean, if I'd have tried that case, I'd have done a million things different. I mean, made a million objections that did get made.
But I mean, this evidence is there that we must deal with.
But, right.
And the court said we don't mention this to make it sordid. It's just it's a pretty unique kind of circumstance to be discussed by both he and the physical circumstances of this victim.
Right. But what you also have to understand is before he was questioned by the police and made those statements, he'd already been questioned by them once. It was many days later. It was all over the media in terms of that. I mean, frankly, I would have presented evidence that it was reported in the media that, you know, she had been menstruating, or I would have developed evidence from the police officers that they confronted him with that type of thing. But, you know, they're equivocal statements. I mean, I look at that from a defense lawyer, from somebody who I see as being, you know, he'd been in prison for 9 or 10 years from age 17. He was trying to, you know, he was being focused on an investigation by the police. The mentality of that type of person is, if the police think I did it, I'm going to be in trouble. He was trying to swing a deal with them where he was trying to say, you know, hey, could you talk to me as a friend? I mean, you know, he was trying to do damage control at that point, in my opinion, and that's how I would argue some of these statements he was making, is he was simply trying to play with the cops to see if he could get them to, you know, work some kind of deal. I mean, there's other ways to interpret those statements. And I just can't get past the point. When you go down the list of evidence against him, the jailhouse snitch was never impeached by his deal because it wasn't disclosed. The blood evidence has been destroyed. Hair evidence that was class characteristic of the ultimate biggest class you could ever get was destroyed. The fiber evidence was destroyed. Although one witness claimed he saw scratches, numerous other people saw them. None of them reported scratches. And then you have the testimony of the bartender. That's the evidence. Every single area of evidence in this case is attackable. And now you have one more piece to the puzzle that says the person who put him with the victim was wrong. And Mr. Soto Longo doesn't carry the baggage that Mr. Vasquez did, where the prosecutors get up there and confront him with the fact, you have no respect for the law, you brokered a drug deal. And his credibility in the eyes of 12 jurors would have gone downhill from there. Mr. Soto Longo didn't carry that baggage. And so I would submit to the court that when you analytically, you can't just sit here and go, well, there was this evidence, this evidence, this evidence. You have to look at how much weight do you give that evidence, what ways is that evidence attackable and was attacked. And one thing we haven't talked about yet is Jones. Jones, well, we talked about Jones, but this aspect of Jones where...
Mr. Norgard, you're now well into your rebuttal.
Okay, if I have a minute 31, I'll save it for rebuttal. Thank you. Thank you. I looked at the clock thinking that's how much time I had left in my 17 minutes and didn't realize I hit the 3.
Total.
May it please the court, Assistant Attorney General Stephen Ake on behalf of the state of Florida. The defendant's successive motion in this case is untimely under the rule of Criminal Procedure 3.851 subsection D2. The trial court found as much as to the first issue, but erred in finding that appellant had met his threshold requirement of establishing due diligence under subsection D2A of that rule. The trial judge in this case focused on trial counsel's due diligence in failing to discover the evidence regarding Soto Longo and totally ignored collateral counsel's diligence requirement under that rule. I'd like to address that part of the
well, can we let's stick with, before we get to procedural bars, because we do have someone who's about to be executed. So you could first focus on, just let's take that Soto Longo did testify now. Did he have any motive for himself for lying at this time?
Soto Longo gave a statement 4 days after the murder to a detective in this case. It was turned over to trial counsel. He's been known for the last 32 years. He now has come in and said something different than what was in Detective Hitchcock's.
Is the record clear that Soto Longo's statement was turned over, or that nothing was turned over because he didn't have anything to say?
No, the police report from Detective Hitchcock's was turned over to trial counsel. They did an affidavit in this proceeding that said they had it back at the time of trial. It was definitely given
as I read the beginning, just right before trial started and then selection of the jury, it appeared to me that Vasquez's name was even delivered late, and the state was arguing that these were not inconsistent or impeaching witnesses, that they really had nothing to do with whatever they had to say was not really material. And I don't even remember the name Sotolongo being presented at that time.
Well, the issue that you're talking about, Your Honor, dealt with Vasquez and Spitzik, Steve Spitzik, the person that went with Waterhouse to buy the marijuana. That was an issue that's been litigated for years about the states turning that over on the eve of trial.
Right.
This police report, trial counsel admitted they had this police report with Sotolongo's name in it. There's no question they had that. They got that. They did a motion.
Is that police record in the
Yes.
record here for this proceeding?
Correct, Your Honor. It was one attached to our answer to the successive motion, and it's also part of the record as it was introduced into evidence at the evidentiary hearing. I believe it's a 9-page long report from Detective Hitchcock's that basically chronicles from the time they find the body till they arrest Waterhouse, and it's. I would point out that only 4 witnesses are discussed in this report that were at the lounge on the night of the murder, 2 of which were the couple that drove the victim to the lounge and ended up dropping her off. The other was the bartender that was a key witness in this case, and then you have Sotolongo. And in this report that was turned over, Sotolongo says, I know Waterhouse and I recognize the victim, but I didn't remember when Waterhouse left because that's not something I keep track of. That's what was said in the report, is that he didn't know when he left. Now, 32 years later, he's come in and testified basically that he still doesn't know what time he left. He gives statements all over the board basically as to when he got there, whether he was even working that night or what have you, but he still doesn't know what time Waterhouse left. But he now claims, I told Detective Hitchcock's Waterhouse left with 2 other males.
But if let's just assume, and again, trying to get this to where we're looking at whether this would produce an acquittal on, the second or third prong of Jones.
Right.
Let's assume that he, in the light most favorable to the defendant, that he verifies that he left with 2 men. And that's consistent with Vasquez, who says that at some point that night he left to buy marijuana.
Right. Right. His testimony would certainly be cumulative to Vasquez's testimony.
I guess that's, and I know the state wants to get, well, we can't be litigating this 32 years later, and I appreciate, unfortunately, the nature of the death penalty is such that in those last weeks you look and you just want to make sure that we're executing a person who committed a crime and is not innocent of the crime. So, that's why I want to make sure we focus on that Sotolongo, at the best, is saying that this Waterhouse left sometime that evening.
Right.
And what probably happened is he went to buy marijuana.
Right. And Vasquez's testimony is far more detailed and far more defense-friendly than Sotolongo's testimony. And the jury heard Vasquez's testimony and rejected that. And Vasquez had timelines. He said that Waterhouse and Spitzik and Waterhouse's friend all left about 5 or 10 minutes before 12 and were gone about 45 minutes. As Justice Lewis was asking questions, Vasquez then said they returned and dropped Spitzik off after this 45 minutes, which would be about 12:45, give or take, and that Spitzik re-entered the lounge, and Vasquez said Waterhouse and his friend stayed in their car and drove around the corner. He conceded on cross-examination that they may have very well come back into the bar, that Vasquez is working one door of the bar. There's multiple entrances to it. You have the bartender, Coey Jin, in this case, testifying that around 12:30, the victim moves over in her seat and starts hanging out with Waterhouse and having drinks. And the bartender's serving them. She recalls exactly what they're drinking: White Russians for Waterhouse and Tequila Sunrise for the victim. Waterhouse confirms that when he talks to the police about, I was drinking White Russians that night.
And the couple that the victim went to the bar with confirms that they left. They were all going to leave, and the victim wanted to stay.
Correct.
And that they left and left her alone.
Correct.
Okay,
right.
So they don't have any information with regard to any connection after that.
Right, and they never testified about knowing Waterhouse or seeing him there or anything like that. They left, and their testimony was they left around midnight, right about midnight. And then shortly thereafter, that's when the victim moved over and hooked up with Waterhouse.
And it's the bartender that places Waterhouse with the victim, but Waterhouse also admits that he met the victim that night, or did they know each other previously?
Right. Originally he tells detectives he doesn't know her, and then subsequently he says, "Oh yeah, I know her, and we've had relations. I've known her for a few months. We've had sexual relations over the past."
Okay, so the idea that they'd be together that night would be consistent with what Waterhouse told the police.
Well, I think a lot of it's consistent with what Waterhouse told the police. Counsel tried to downplay it, but I think Waterhouse made several incriminating statements that are directly linked to what happened in this case. He talks about his drinking in excess that evening. He had, I think he said 8 beers before he went to the lounge, and then he had 4 or 5 White Russians, which Koyajin testified to serving him White Russians. He said he became frustrated when a woman was menstruating, and that like flipping a switch, that he would get violent and do terrible things. And he said that happened on the night of the murder. He said that happened Wednesday night. He told the police officers that. He also told them, "Why do you think I quit drinking after that?" Because of these problems with his violence and drinking. So that all is consistent with what happened in this case. The problems with the woman menstruating, as this court's aware, she had a tampon down her throat and was dumped in the mud flats. She had been savagely beaten. Waterhouse's boss had testified that he had seen a tire iron inside of Waterhouse's car a week or so before the murder, and that was not there when the police impounded the car. There was blood spatter all throughout the car. There's photographs of that, and it was introduced into evidence. I think the trial judge in this case, in analyzing the merits of this, correctly found that there's no way that Soto Longo's testimony would probably produce an acquittal in this case. But I still want to talk about the due diligence problem, because I think this court needs to find that this is an untimely motion under the rule. Soto Longo's name has been out there since 1980. It easily would have been discovered. The whole defense theory in this case was that Detective Hitchcock...
Have we addressed at any time in our precedent circumstances where witness A tells a police officer, "I know nothing," and then later on that witness says, "No, you know, more I think about, I do know something," and that we have held that counsel's performance is not diligent, or that there's ineffective assistance for not investigating witnesses who say, "I don't know anything"?
Well, no, Your Honor, not specifically. There's no case law that I'm aware of.
So to get there, we would have to be saying, I mean, basically that diligence for both initial defenders and collateral counsel, they would of necessity be required to speak with everybody whose name is ever mentioned.
No, Your Honor. I think you have to look at it under the circumstances of this case. Well,
where does that lead us, though? I'm just asking because you're saying that this name is there, and this should have been discovered at the time. Well, the reason that it wasn't, I'm assuming, is because everything indicated this witness didn't know anything.
Well, Your Honor, again, I think...
Is that an assumption correct?
No, that's definitely what the attorneys said in their affidavits, and that's the only representation that collateral counsel has ever made, is that I relied on the veracity of what was in the report. What our position is given the facts of this case, that the whole defense theory is that Detective Hitchcock was not accurately recording information, that it was incumbent upon counsel to go and investigate who Detective Hitchcock had talked to. And in this case, we're talking about 4 witnesses.
Case, then. You are saying that. In every case, then every defense counsel, and no matter what stage, would be required to go behind every document and investigate.
No, Your Honor.
Well, why not? I mean, that's just what you've just said.
No, Your Honor. I think in a generic sense, no. But in the fact-specific sense of this case, I think it's a yes. I mean, in a regular murder case, I think it would be prudent for counsel to go and talk to all the witnesses. But admittedly, if there's a police report that says witness knows nothing, it may not be a requirement to go talk to that person. But in this case...
Well, that would only be in hindsight, then.
Well, I think this should have been...
That's only after the fact, and then the state says, aha, due diligence, got you.
This really should have been an ineffective assistance of counsel claim when you think about it, that trial counsel didn't investigate one of the 4 witnesses that's listed in a report. I mean, realistically, trial counsel should have gone and spoke to Soto Longo, having seen this report, especially when they're presenting evidence They called Vasquez to the stand, and Vasquez said, I told Detective Hitchcock this. He didn't want to listen to me. Detective Hitchcock says, oh, I'm not here to build your defense case. So based on that, they had a report from Detective Hitchcock's listing 4 witnesses. They should have gone and talked to Sotolongo at that time. And the fact that nobody's done it for the last 30 years, given that defense, shows that counsel has not been diligent in this case.
But I guess, so you're saying Vasquez testified differently than what Hitchcock said he said?
Vasquez said, I was interviewed by Detective Hitchcock. I told him I saw Waterhouse leave with these 2 men, and he said he didn't want to hear it, was Detective Hitchcock's quote, according to Vasquez's testimony. Then the state recalled 2 detectives, Detective Long and Detective Hitchcock. Detective Long said, I spoke to Vasquez. He told me about him leaving with 2 individuals, and I wrote a police report to that effect. They also called Detective Hitchcock, and he said, I got information from others about Vasquez. I interviewed him, and he told me that they left around 10 o'clock or so at night, is what Detective Hitchcock said Vasquez was telling him, was that Waterhouse had left with these 2 men about 10 o'clock at night. He denied that he had ever said, hey, I don't want to hear about this. So the state put rebuttal testimony on to refute Vasquez's claim that Hitchcock's wasn't.
So you're saying that because there was reason to doubt Hitchcock's police report back then, the original trial counsel should have investigated.
Correct.
But you see, the problem is, this case, you have, to me, the stronger argument is that we've listened to this now and doesn't meet the Jones standard. I would hate, and this is where we really, whether death is different, assume that Sotolongo, who has no prior police record, comes forward and says, I actually saw the victim leave with another man, and it's credible. You would have us say we're going to disregard that an innocent man may be put to death because the original trial counsel back then didn't investigate him. And that's just, it's that rule that's so broad that, the procedural bar that even on a case recently from the U.S. Supreme Court, they said, we just have to be careful before we're going to fault lawyers when we've got somebody who is on death row. So that's my concern here, that you may have a point, and maybe we should say that lawyers should be questioning everybody, or maybe we should say prosecutors should be questioning everybody in a police report so we make sure that the police report's accurate. I don't know what, where it is, but I'm just concerned about that rule here.
And that's why I think it needs to be done on a case-by-case basis, and you have to really look at what transpired in this case to find this diligence thing, because I agree with what your honors are saying, that there may be cases where it may not be, you may not want to set that bright line rule that counsel has to go out and interview every single person again. But in this case, given the facts of this case with Detective Hitchcock, I think it was incumbent upon either trial counsel or any of the counsels in the past 32 years that have been reviewing this record to see what was the argument by trial counsel at trial. And in addition to presenting that testimony from Vasquez that Hitchcock wasn't listening to him, he argued that extensively in his closing argument that Detective Hitchcock wasn't listening to him.
Did Sotolongo come forward when he saw the death warrant had been signed, or did they go out and investigate?
No, he came forward after seeing a newspaper report. But I'd point out
but isn't that sort of important, because the idea is that and he's a citizen of this state. I don't understand why he waited, but he saw something, the guy's going to be executed, and he comes forth as a citizen. And what we're saying really is that Mr. Norder, who is, has always been an excellent advocate in front of us, should have figured that out 8 years ago, and that trial counsel should have figured that out 32 years ago when the guy comes forward on his own volition.
Well, I can't attest to why Sotolongo came forward so late. He testified that he was friends with Vasquez. He's been friends with him for the past 30-something years. He knew Vasquez had testified to this, and he being Sotolongo, wasn't there testifying to this.
But doesn't the system actually end up evaluating, as Judge Beach did, to say, listen, he waited 32 years, I don't find this real credible, and his memory is not good. So the system looks at that witness and now says, it's really lacks the kind of veracity in terms of impugning the verdict.
Right.
And that's what sort of happens usually with these late, these late witnesses. But normally it's usually some jailhouse snitch that comes forward at the last minute to say, oh, I really didn't mean it.
Right.
Here we've got somebody who has no reason really to come forward now, other than conscience bothered him or something.
That was his testimony, correct, Your Honor. And that's exactly what he said. He basically said that was why he came forward. But again, he's known about this. He knew Waterhouse had got sentenced to death back in 1980.
So should we so that's what I'm saying. Should we punish the lawyer? Should we punish Waterhouse for the fact that a citizen waits to come forward?
Well, I don't think it's necessarily you're punishing them.
Well, we sort of are, because you're saying we should never have even heard what Sotolongo had to say. That's what you're saying.
Well, I'm saying that they had an opportunity at the evidentiary hearing to establish their diligence in ascertaining these facts, and they failed to do that at the time. That's what I'm saying, Your Honor, is that under the rule, unless you want to open the floodgates for counsel to come in and litigate things years later, that's always going to be the case if you're not going to require any kind of diligence in raising this claim under successive motions under subsection D2. That's why that rule is there, because otherwise you get counsel coming in 30 years after the fact raising something that should have been raised years before.
Your opposition suggested, I think, in a question from Justice Pariente, that there is some question whether this trial judge actually rejected the credibility of this witness, or that it is unclear in this final order with regard to findings of materiality and with regard to veracity, that kind of thing. What is your position, and would you tell us why?
I don't think it's unclear at all, Your Honor. He says his testimony is unreliable given the passage of time, and that he found Detective Hitchcock's was accurate when he testified, that had this statement been made to him, he would have put it in the report. So he made a strong determination based on the conflicting testimony from both Sotolongo and Hitchcock's at the hearing, and that's on page, I don't have the record site, I'm sorry, but it's page 20 of 21 of his final order denying this claim. Is he basically says that Hitchcock's is a more reliable witness in this case, and that his information was reduced to writing at the time, and he credits Detective Hitchcock's and not Sotolongo.
Well, if that is the bottom line, and this court accepts that ends the inquiry, does it not?
It does. As far as any kind of Brady claim or anything like that, yes, Your Honor.
I mean, all of that, other than the destruction of evidence, it destroys
right.
Brady, it destroys Jones, all of those kinds of claims.
Right, and I think when you look at it in comparing Sotolongo's testimony versus what you have at trial, I don't think there's any question that the trial court properly denied this claim based on the materiality aspect of it. I've gone over the evidence as to his statements and the blood spatter and all that. I don't think there's any question that had the jury heard Sotolongo, they would have rejected his vague testimony, just like they rejected Vasquez's testimony, which was far more detailed and defense-friendly. So, as far as real quickly on the first issue, I just want to point out, as the court's already noted, that this was an issue that has previously been raised. The only new argument in this case is basically now death warrant's been signed. This is something that counsel could have argued back when he was presenting this case in 2003. And I see my time is up, so I would ask this court to affirm the trial court's ruling. Thank you.
I'm going to talk fast. On the issue of Sotolongo's credibility, the judge found that it was newly discovered evidence. Also, as to the first prong of Brady, found that his testimony was material. Where he got into digressing from Sotolongo's credibility was between Hitchcock's memory about the report and Sotolongo. But nonetheless, he found Sotolongo's testimony to be material. He did not reject it. There are 5 blocks of evidence in this case. You have Mr. Waterhouse's statements, which I submit as equivocal. His statements to the jailhouse snitch is equivocal and impeachable, although it wasn't because of a Brady violation. The blood, hair, and fiber evidence is all class evidence, which has now been destroyed. The scratches were seen by one person, despite numerous people seeing Mr. Waterhouse post-event, including police officers. And what the prosecutors back in the day argued was critical evidence, Kyogen putting them with Mr. Waterhouse. Now all of a sudden, well, that's not the most important evidence. In their closing arguments, that was extremely important to getting a conviction, was putting Mr. Waterhouse with the victim. Now we have not only one witness, but two. And when the state says that Mr. Vasquez's testimony was rejected by a jury, I don't think it would be rejected by a jury if they had Soto Longo to corroborate him, or he was not subject to the same impeachment as Vasquez. Extremely important witness. Should grant relief. Thank you.
We thank you both for your arguments.
Good seeing everybody, and I didn't know you were a moccasin. They have a story in the Ledger about you.
We will now move to the second case on today's docket, Oyola versus the State of Florida.
May it please the Court. William McLean, representing Miguel Oyola. Mr. Oyola was convicted of murder, false imprisonment, robbery, and auto theft. The homicide victim in this case was Mr. Oyola's employer. He had a landscaping business, and Mr. Oyola was assisting in that business. The prosecution's case here was prosecuted on the theory that Mr. Oyola had improperly used the business debit card and taken money from the account. Mr. Gerard, the employer, discovered the missing money. According to the bank clerk, when he was surprised to see it missing, appeared angry and left. The inferences that he confronted Mr. Oyola about this, we don't know exactly the details of what the confrontation entailed, other than the fact that Mr. Gerard was killed from blows from probably a shovel and stab wounds. There was actually an eyewitness to a portion of this fight, if you will, a gentleman who was going down a logging road and came upon Mr. Gerard's truck and trailer. He said there was a gentleman outside the trailer. He went in the trailer. There was movement in the trailer. The two men came out of the trailer fighting, and he left to get assistance. And when they returned, the truck and trailer was gone, and Mr. Gerard was discovered. He was alive when they first got back, but he died person immediately.
Did the eyewitness give of the person who was not there, that was fighting with Mr. Gerard? Because as I understand it, he didn't actually see him, but he gave a description of him?
He saw the two gentlemen, and one of them was, he referred to the heavier set man being Mr. Gerard, who was still there at the scene, versus the other man. There was other evidence that tended to link Mr. Oyola to the offense. Besides that witness, there was circumstantial evidence, there were some statements. We're not taking an issue with the state's proof that Mr. Oyola was the perpetrator here.
Well, you're not challenging any part of the guilt phase?
No.
All right, so going to the part you do challenge, you challenge the HAC aggravator, but not the finding of the aggravator.
That's correct, Your Honor, and actually the point that I would make regarding the judge abusing his discretion and giving great weight to the HAC aggravator also ties into issue 2, which deals with the judge's treatment of the mental mitigation in general.
Well, he gave great weight to all 3 aggravators.
He did.
And if he gave even medium weight, you're not challenging the HAC aggravator. There are two other aggravators in this case, which are that he had prior violent felony, or was he under probation? What was his?
He was on probation for, at the time of the homicide, for a 2006 grand theft.
Okay, so it wasn't a violent felony.
No, he was convicted of a robbery in this case. And
he had a robbery. He was on probation for another crime, and the third
was the HAC factor.
So those are you're really not challenging proportionality if, I mean, again, even if the HAC was given, these aggravators. There's HAC here, and whether it's the worst HAC or the less HAC, we don't qualitatively. It's a important it's a strong aggravator. So I guess what I'd like you to sort of tell me is how, with the facts of this crime, that even if the judge found some mental mitigation, how that still changes the equation in this being either a proportionate sentence or one that would have to go back for, I guess you would say, resentencing. I'm trying to understand where this all fits together.
Well, the argument I've made with the HAC was that the judge abused his discretion in the way of affording it because he didn't take into account that this crime, the manner of this killing, was to a large degree driven by Mr. Oyola's mental illness.
And I guess I don't know, have we ever had, because HAC focuses on what the nature of the crime and what the victim experiences, I don't know, do we have a case that says that if there is something that would be a mental mitigator, that should then lessen the weight given to HAC, or maybe it might be that if somebody is really certifiably mentally ill and can't control his actions, you take that and give that more weight, and that may balance out. But I don't think you diminish the weight given to HAC in that situation.
I don't know that this court has specifically held that. I have cited cases from this court in the past where the effect of it was we can't take into account the severity of the HAC to the degree to give great weight to it. It wasn't talked about in those terms, but because of the mental illness that was fueling the manner in which the death occurred, that this court looked at the HAC in a different light.
Well, and we can do that. I mean,
yes.
If we're looking at proportionality, we can do that. If we look at it and say this was the product of somebody who had a depraved mind. But here you've got a situation where, what I'm understanding this to be, again, is something. Your client was stealing money from his boss, right?
Yes.
Okay. And the boss confronted him, and he wasn't happy about that, so he started attacking his boss, thought he maybe had killed him, puts him in the trailer, leaves him to die, where he's going to take him now someplace where he's going to dump his body, and lo and behold, he's not dead, so he has to continue beating him, and instead of killing him completely, he leaves him helpless, and he leaves. Is that what this crime's about?
Well, that's the state's theory.
Well, that sounds like, that does seem like it conforms with the physical evidence and what was observed at the end. It just doesn't strike me that somebody who is, this is like, again, this mental illness that he has, and then what he does afterwards, not that affects HAC, but he very carefully tries to hide this crime.
I think
it's not a crime of passion, certainly. It's a
after the crime actions to try to cover it up. I think that's a different question than what happened.
Well, I understand, but it just shows what his mental state is. In other words, if somebody, we've seen cases where after somebody kills somebody, they wait till the police comes and goes, "Oh my God, I can't believe what I did. I just lost it."
Sure.
That's not this case.
That's not this case. Okay. That's not this case. The concern that I have is that the trial judge analysis here, both for the HAC factor, but also more importantly for rejecting the statutory mental mitigator in this case that I've raised in issue 2. The judge really never made any analysis in the order as to why he was rejecting this.
Well, that's on that point. Frankly, I didn't know why you didn't raise that. What he actually does is he lumps every bit of the non-statutory mitigators together and says the alleged non-statutory mitigation includes serious drug abuse, an abusive home as a child, a cycle of violence, and mental disorder. While the evidence established such circumstances, it gives these circumstances slight weight in weighing the aggravating circumstance against the mitigating. That seems to me to be an error in how he evaluated, because he's supposed to. But you don't raise that as a separate point on appeal. I mean, that he lumped everything together and doesn't explain why he's only giving those slight weight.
Well,
or is that a point? I didn't see it.
Well, I raised the whole question of how the trial judge really did not do any evaluation as to the mitigating circumstances, and specifically rejecting the statutory, and then he does lump them all together.
But you didn't, and again, you're an experienced appellate lawyer in death cases. I read what you were saying is that he was wrong in rejecting the statutory mitigator of extreme emotional distress. Is that not what your point was on a...
I did raise the issue as to a Campbell violation in the way that the mitigation was treated.
Okay, so
it was sort of involved in this. I kind of included in the same issue the Campbell problem, but the analysis, the judge made no analysis, not only for the statutory, but again for the non-statutory. I mean, he gave. As to the statutory mitigating factor, he simply said, I don't think the evidence is sufficient, period, with no analysis, even though we had unrefuted testimony from the defense expert witness. That
what did the defense expert witness actually say that you think would substantiate these mental mitigators? Because as I see the evidence, there really isn't a lot that really was given here that would really substantiate it. And then when you put that in perspective with what this defendant actually did, it seems to me that the trial judge was correct in rejecting it. He may not have set it out properly, but what do we have that really would have demonstrated he had a severe mental illness here?
Well, Dr. DeRico actually evaluated Mr. Oyola on 2 different occasions. He was first arrested in 2008, and on a pending probation case, he was evaluated and was declared incompetent and was hospitalized for treatment and restoration of competency because he'd been off his antipsychotic medication. He was diagnosed with schizoaffective disorder, which included symptoms of hallucinations and paranoid delusions. He also indicated that Mr. Oyola, and particularly as to this case, he said when he got in a stressful situation, he was likely to interpret even a verbal confrontation, even an angry verbal confrontation, as a life-threatening event, which would have prompted him to overreact to the circumstances and lose emotional control. So we don't know exactly what the confrontation was. We don't know. Mr. Gerard, I don't think there was any evidence that Mr. Gerard pulled a weapon on him, but there was certainly no evidence that we don't know whether Mr. Gerard got violent in any way at the beginning of the confrontation or whether it was all just a verbal, angry confrontation. But Dr. DeRico indicated that even a violent, quote-unquote, violent verbal confrontation would have caused this overreaction because at the time of this crime, he had been off his antipsychotic medications. And he did have a history of delusions. He had a history of hallucinations. And Dr. DeRico did examine him again in June of 2010 before the trial of this case and further determined that these mental illnesses were still in place, even though at that point he had been on medication.
Let me ask you this. Does the defendant's actions before and after the actual murder took place, play it all into our determination in looking at this as to whether or not this mental illness as such fit into the statutory framework?
I don't know that you can look at what he did afterwards, because the statutory mitigator that Dr. DeRico indicated that existed wasn't that he might not have been able to appreciate the criminality of his actions, but he was unable to control them. And that was the foundation for that statutory mitigating circumstances that Dr. DeRico testified to. And once the confrontation is over, I mean, the emotions come down, he may have been able to carry out, logical type activity to cover up the offense. So I don't know that we can focus on what he did afterwards to cover up the crime as reflective of what happened at the time of the crime.
Isn't this the case where there's evidence that the victim was in the trailer, locked up, trying to get out of it? Do we know at all how this all occurred? This is really, to me, a little bit
we don't know
strange
we don't know how it occurred. And that's another point that I made on the heinous, atrocious, and cruel factor, is that the judge accepted the prosecutor's argument that the event started in one place, he was transported in the trailer to the second place where the witness observed them fighting, continuing to fight. There is an indication that at some point bloodshed occurred in the trailer. There is an indication that, well, obviously they were in the trailer when the witness saw them too. But whether the fight started there or whether it started at an earlier location, there's no evidence of that.
Were they in the trailer when he first saw them, or outside the trailer?
When he first arrived at this trucker who came to up on them on Logging Road, he said he saw an individual, thought he saw an individual outside the trailer. Then all of a sudden the trailer was moving, and then both of them tumbled out of the trailer in this big fight. And that's when he moved back to get assistance, and then when they returned, the truck and trailer were gone, and Mr. Gerard was found on the side of the roadway.
When was just go back to this disorder that he had? What records were introduced by the defendant at trial? When was the last time before the murder that he was treated for this mental illness?
Before the trial?
Before the murder.
Before the murder, I'm not sure that, I don't recall exactly when the testimony was when his treatment last occurred. I know there was evidence that he had actually been incarcerated in Philadelphia in 2006 and was on treatment there. There was records of that. I don't know how long, without reviewing the record again, I don't know that.
In terms of looking at this and how it caused him to perform erratically during his life, I guess, we look at the whole picture. How old was he at the time of the murder?
He was, I know you'd...
Well,
he was in his 30s. And I think, as I recall, he was in his 30s.
So he had gone his whole life up till his 30s having this mental illness and had managed to not be a violent person, right? That reacted and fought people. I mean, this isn't what he was.
We actually don't have much in the record as to what kind of events may have been occurring in his life. He did have a prior conviction, I believe in the Philadelphia case, for a theft of some kind, as I recall.
See, I guess it's like it's this idea that somebody, again, for the statutory mental mitigator, which is a serious one if it is found and then given weight, that things like the age was, like, again, the classic person that I think about was a defendant by the name of Donnie Lee Crook, who was on Social Security disability for a serious mental impairment that had evidenced itself in many ways during the person's life. So that what you say then is that when someone confronts somebody with stealing money, that instead of saying, no, I didn't, they end up murdering him, But that's what defendants that end up on death row end up doing. They don't make good choices. The question as to whether it was the mental illness that drew it, that was driving it, or greed, or wanting the money and not wanting to get caught, and therefore thinking he can get away with it.
Well, two things. The last one first. I'm not suggesting that he wasn't motivated perhaps by greed when he started taking money from the account. But then the confrontation is a separate event. He wasn't, I think where the robbery came in is there was some indication that Mr. Girard had withdrawn some cash from the bank earlier, and that was missing, and Mr. Oyola had cash after this event. But he did not confront, there was no evidence that he went out to confront Mr. Girard to steal money. He stole the money from the accounts initially. Second, there is family history here that, number one, Mr. Oyola was the youngest of a number of children. His mother likely had schizophrenia. She was abusive to all the children. Every one of the children left home by between the ages of 13 and 15 years old. The older brother testified he was the next one at home before Mr. Oyola was left home alone with this mentally ill mother. Indicated that he had he had anger issues, he had temper issues, he reacted, he did react and got in fights over rather minor incidences. So there was that family history that he had problems in the way he responded to situations in life. So that is in the record through the testimony of the brother.
Mr. McLean, the statutory mitigator is very specific in its wording that you're relying on, correct?
Yes.
Because, very clearly, the expert stated that he certainly understood the criminality of his conduct, so that's not one of the statutory ones that we're talking about, correct?
Correct.
So we're talking about interference with his capacity to conform his behavior, correct?
Correct.
And that's worded very specifically in the statute, correct?
Correct.
And what is your understanding of that, the exact language, the requirements of that statutory mitigator that must be satisfied?
That due to the defendant's mental illness, he lacked his capacity to conform his conduct to the requirements of the law was substantially impaired.
Okay. Was there at some point that this expert testified that it was substantially impaired, other than that the schizoaffective disorder interfered, the symptoms may have interfered with his capacity to conform his conduct?
Well, I would point out,
it's very simple first, and then you can go ahead and...
He did not use the word substantial in his answer.
So now then that's where I'm going, and you knew that. So the question is that do we then not have evidence to satisfy the statutory mitigator in this record, or does a court read in after you look at everything and pull all of it in and say, yes, even though the doctor didn't use those words, that this record provides that substantiality aspect?
I think the latter. You can look at the entire record, the entire testimony. Right offhand, I don't have anything. Okay. But again, it was understood that is what the expert testified to, and in fact, the prosecutor in the penalty phase closing argument acknowledged to the jury that Dr. DeRico had testified that this statutory mitigator of inability to conform his conduct to the requirements of law, he had in fact testified to that. Now, he went on and attacked the doctor's opinion, but he acknowledged that what was understood in the court, that he had given testimony in support of that aspect of the statutory mitigator.
I understand in support of it, but if you don't satisfy it, we can certainly present evidence in any number of things. But I'm trying to get to the real heart of whether this is really satisfied as a matter of law. We can talk around it, but do we need to directly drive the nail into this point of law?
I don't know that you want to. take a specific word that wasn't used in an answer. The question that was asked of Dr. DeRico at the time tracked the language of the mitigator.
Well, but
and he responded,
did he answer that, though?
I would think he answered in the affirmative. Now, rather than regurgitating the same wording, and it's perhaps the defense lawyer at the time should have probed it a little further, but he did answer in the affirmative that there was impairment of his ability to control his behavior, and then due to his schizoaffective disorder and his untreated psychotic condition, that he would have reacted and he would have lost emotional control. I think he used that terminology as well.
How long had he been without medication?
Without looking at the record, that's unclear. It was long enough that he was no longer in treatment.
Okay.
I mean, the expert who examined him in 2008, right after his arrest, said he was untreated, and he sent him to the hospital and declared him incompetent.
And we have nothing in the record to show the last time he was treated for this disorder.
I don't remember anything in the testimony. Whether there's something in the records, I can't say absolutely not.
But he was treated
untreated
the last time he was in prison?
There was records, at least I think in 2000. There was records from Philadelphia, I want to say was sometimes early in 2006. This offense happened in December of 2007. The report was the expert's thing was he was untreated for the psychotic, schizoaffective and with psychotic symptoms.
Prison for how long?
I'm sorry?
He had been out of prison for how long at the time this murder took place?
That's not clear in the record. As I recall, I don't recall it being outlined in the record exactly how long that was.
Can I, just a question.
I'm sorry.
On the statutory mitigators, I'm just looking, because I'm looking at the statute itself. You've got under 6F the capacity of the defendant to appreciate the criminality or conform to the requirements of law was substantially impaired. But then there's another section, and it has to do with, it's where it talks about that the felony was committed while the defendant was under the influence of extreme mental or emotional disturbance. I'm not seeing why. Aren't those two separate statutory mitigators?
They are two separate statutory mitigators.
And you're only arguing the one about the appreciate the criminality of the conduct?
That was the only one asserted below by a defense lawyer, trial counsel.
But you're not arguing conformist conduct.
Yeah, no, he is.
That's the one you
I am arguing that.
I was asking about the extreme
emotional disturbance.
Okay.
I don't know why it wasn't asserted below, but there wasn't an assertion of that.
You are now into your rebuttal time. You have about 4 minutes left.
I will retain that time for rebuttal. Thank you.
May it please the Court. Meredith Carbula, Assistant Attorney General, Attorney for the Appellee. Justice Quince, to answer hopefully quickly your question, he was released from the Philadelphia prison in 1999. Dr. DeRico testified that the working diagnosis while he was incarcerated was schizoaffective disorder, and he was in medication, but that was in 1999 when he was released. He was 37 years old and 10 months at the time of the murder.
What was the crime in Philadelphia?
Possession of cocaine and robbery. But apparently, I think the reason that the prosecutor didn't go, and there was some discussion of the record about prior violent felony, was that the statutes are somewhat different, and so the prosecutor didn't present any evidence of a prior violent felony based on that robbery.
Was that the one that he was on probation for, or was there then a grand theft?
In 2006, he was placed on probation for grand theft auto and grand theft. He was placed on 5 years probation with 6 months in county jail as a condition of that probation. He was still on that probation at the time of the murder. I think that one of the things that is very critical to this inquiry was honed in on by Justice Lewis, and that is that this Dr. DeRico never testified that the capacity of the defendant to conform his conduct to the requirements of law was substantially impaired. He was asked that specifically. It was asked specifically, and you can find that on page 504 and 505 of the trial record. He was asked specifically whether Oyola's capacity to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. And, you know, Dr. DeRico did not say yes. In fact, what he said was, I thought he mentally understood the criminality of his conduct. And then he went on to say, but I thought the fact that he was uninvolved in treatment for a schizoaffective disorder interfered with his capacity to conform his conduct. When asked what he meant specifically, given another opportunity to opine on the statutory mitigator, he said, well, that those untreated symptoms very likely contributed to his excess overreaction to being attacked by the victim, which was likely related to his symptoms of loss of emotional control and impulsive behavior. So, first of all, Dr. DeRico and the evidence in this case is contrary to what the information Oyola gave to Dr. DeRico of what happened in this case. And that was the state's attack on Dr. DeRico primarily is that Oyola lied to him and that he was basing his opinion primarily on the impact of the schizoaffective disorder on Oyola at the time, on the fact that he was attacked by the victim. But the evidence in the case is to the contrary. Going back to, quickly if I can, Justice Pariente, or as long as you like, as far as the HAC, this court has never held that a trial judge is obligated or abuses his discretion in giving great weight to the HAC aggravator, which this court has consistently said is one of Florida's weightiest aggravators because the defendant is mentally ill. All the cases cited to by the defendant in his initial brief were proportionality cases, with the exception of one which was remanded back for a new penalty phase because future dangerousness was at issue. Not a single case has this court said the aggravator should be given less weight because of the mental mitigation.
What you do instead is you look and see whether the statutory mitigator has been met, and then you may weigh.
And you weigh it, exactly. And that goes to a proportionality issue, which wasn't raised in the initial brief. So
when you say initial brief, is there a reply? There wasn't a reply brief.
No reply brief. So proportionality wasn't raised, and so I think it's sort of smushing together this notion of weight, and I think you have it exactly right. Is the trial judge has broad discretion to determine the weight he gives to an aggravator, and this court won't interfere with it as long as there's competent, substantial evidence to support it. And the thing is, Your Honor, as I say, as a matter of law, this court has held that it's most weighty. But in this case, we have, and it is not speculation what happened in this case, because we know that Mr. Gerard was knocked on the head with a shovel. We know from Dr. Flanagan, the medical examiner, that was sufficient blow to knock him unconscious. So the state's theory at trial, which is supported by the evidence, is that Mr. Gerard was, and by the way, this blows all came to the back of the head. And indeed, even the stab wounds came from behind him. So that the state's theory was that Mr. Gerard was knocked in the head, may have been stabbed at some point as well, but primarily knocked in the head, knocked unconscious, confined in the trailer. And if you look at the testimony of Sean Yao, who's the CSI, he testified about the blood that was in the trailer. And it was clear from the blood in the trailer that at some point Mr. Gerard is laying down bleeding. And he's also aspirating blood. There's fine mists of blood on the door and on places in the trailer where he's aspirating blood from his nose and mouth when he's down on the ground. And there's also evidence, and most critical, is that there's evidence that he is breaking down the door. He obviously regains consciousness. There's no reason for Mr. Gerard to be out on this logging road off Tram Road, except for that Mr. Oyola has driven him there. Now, we know that Mr. Gerard didn't drive him there. He has the keys in the pocket. The only other set of keys is Mr. Oyola's.
And that's the basis for the false imprisonment claim.
Exactly.
And that's not challenged.
That's not challenged. And I think what happened during the closing argument, during the guilt phase, was that trial counsel argued that it wasn't kidnapping to facilitate a felony because Mr. Oyola thought he was dead already, and so I think that's a rational explanation for the jury to find him guilty of false imprisonment as opposed to kidnapping to facilitate a felony, and that's exactly consistent with the evidence. Mr. Girard was confined. There's blood all over the trailer, and again, the color photos would be very helpful in you seeing the level of violence. But there's evidence on the door where the door's made of plywood. And we have testimony that prior to around 2 o'clock when he dropped his crew off, Muncho testified about that the door is perfectly fine. And we have evidence that the door is completely busted. It's got a plywood front, and it's fractured to the side, vertically, where he is desperately trying to get out of the trailer. There's blood all over the door frame, and where he's putting his fingers in the space he's managed to make. Because if you look at the photographs, and that's of Mr. Girard in this case, he sort of looks like a rugby player. He's very well built, very muscular, very strong, and he almost managed to get out.
What is the difference, the weight difference between Oyola and the victim?
The medical examiner did not testify as to the weight of Mr. Girard, but if you take a look at the photos, you see he looks like he's not exceptionally tall, but he's very well built, muscular, and I don't mean fat. I mean well built, like a rugby player. Mr. Oyola was 5'9", and the weight in the record ranged from 176 to 200. Mr. Miller, who was the gentleman who saw him out on the logging road, described him as a skinny guy. So whether he was lighter at the time, because he was arrested on this after the indictment in 2008, I don't know. But what I do know is that I think one arrest report refers to him at 176 and one at 200.
So is there did the state advance where the initial struggle occurred? Did it occur? But it didn't. It occurred outside the vehicle.
Certainly.
But do we know what the initial instruments used to apparently attempt to kill or Mr. Girard at that time, what he used?
Not conclusively. Some of the struggle happened in the trailer as well because there was blood evidence. It was consistent with Mr. Miller, who's testified that Mr. Oyola, of course he didn't identify him as Mr. Oyola, but that the guy who was outside the trailer, and we know that Mr. Girard is locked inside the trailer, went inside, and there's evidence of sling-off blood from the front to the back. So we know some of it happens, but we don't know exactly where the attack happened. It was probably close to where Mr. Oyola lived because the place where he drove to dump the body was in close proximity to his home, within about 5 miles. So, but we don't know that, and I have to say, we don't know where the original confrontation occurred.
But the bottom line is we know he was significantly injured and lived for a period of time and was able to actually get up and try to get out in terms of this HAC aggravator.
Exactly.
So when the judge finds that it happened at 2 different locations with different objects, there's no question that's supported by the record.
Exactly. The medical examiner testified that a shovel that was found in the abandoned truck, Mr. Oyola dumped the truck off at Kmart up here on Appalachia Parkway. In the back of the truck was a shovel. It was positive for blood. The shovel was bent at an unusual place than if you were using it for, and it had Mr. Girard's blood on it, DNA on it. And he had at least 4 significant head injuries that would have killed him anyway by themselves. Or I think the medical examiner testified that it was a combo of the knife and the blows to the head, that they would have been independently fatal given time. And so he was clearly hit on the head with a shovel. And whether he was, and again, applying common sense and reasonable inferences from the evidence, it's logical that he was hit on the head with the shovel from behind, put into the trailer, and transported out to the logging road. Because number one, there's no reason for him to be out there, out on a logging road.
And just so we know, in terms of the motivation, he's on probation. So if he is accused and he is found to be guilty of having stolen money, his probation can be revoked and he goes back to prison.
Yes, certainly. If Mr.
I mean, in terms of, that's what some of the significance of the significance in this case of the fact, I don't know how it was argued by the state, but that he's on probation is that, and somebody catches him doing something that's illegal, the consequence for him versus another person is, you know, your probation's revoked, most likely, and you end up back incarcerated.
Exactly.
And is that, I mean, or was that not argued that way?
Well, you know, of course, the jury didn't know that he was on probation during the guilt phase. They knew that.
So you didn't use that
wasn't
used as a motivator for...
Not specifically.
But in terms of...
Stealing the money, of course, was that we know that Mr. Girard found out about the improper debit card. Mr. Oyola had the debit card. He didn't steal the debit card. He had the debit card. He was the foreman of the crew. He went out and bought gasoline and things like that. That he used it improperly the day before. That debit card is back in Mr. Girard's wallet at the time his body is found, and there's blood found on the wallet and blood found on the debit card. So that debit card gets back into his wallet. Again, reasonable inferences from the evidence. Mr. Girard went to Mr. Oyola, and interestingly, trial counsel during closing argument kept saying, well, maybe Mr. Oyola got fired. Maybe he got fired. He said, and of course that's speculation because there was no evidence of that. But I think when you look at reasonable inferences, Mr. Girard got that debit card back, and maybe he fired Mr. Oyola. We don't know. There's no evidence of that in the record. I think that's, again, a logical inference. If you find out someone's stealing from you, he got his debit card back, and it's back in his wallet at the time his body's found. So at some point, he's rendered... he's bloody. He's incredibly bloody. He's injured. He's put into the trailer. He's transported out, and Mr. Oyola then realizes that he's not dead because he's got to hear this racket in the back. I mean, and there's got to be sufficient time for him to break the door and even bend the pole. This is a trailer where, if you take a look at the photos, there's a big metal bar that goes over the hasp, and you'd normally put a padlock on it. It's not there. The padlock's not there. But he not only broke the door and pushed out the trim, but also managed to bend Mr. Girard, bend the metal bar in trying to escape. So we know that we don't know exactly how long he was in the trailer, but we do know that he was in the trailer for a sufficient amount of time to cause that much damage to the door and to the frame and to try to get out. And we also know where they stopped. We know because Christopher Miller talked about the logging road, and he saw them stopped. He saw Mr. Oyola go into the trailer. He saw the trailer start rocking, and then he saw them fall out.
He actually saw the defendant go into the trailer.
He saw the defendant. Well, he didn't recognize him, of course, as who he was. But yes, right. There was one man. The truck doors were open, I think he said, or there was nobody in the truck, and he perceived that somebody was standing outside the trailer door and go in. Thereafter, the trailer started rocking. And so it's logic. The only reasonable inference from that has got to be Oyola. He goes in the trailer. He continues the attack.
I thought they were already in there. Rocking and rolling,
he saw the truck and trailer there, and he was kind of angry because somebody's blocking the road, and he perceives more than sees, it seems, that there's somebody outside the trailer. That person goes in, and then the trailer starts rocking, and both of the men tumble out, and Oyola is getting the best of Mr. Girard. Mr. Miller does not see the knife. So how much of the stabbing happened inside the trailer when he went back inside, and how much out?
Let me just, because when I was asking you about the different weapons, the stabbing is that the final? Is the inference is the shovel and the hitting in the head occurs at the one location. The stabbing and the fatal stabbing occurs at the second location.
At the second location. Now, it may be that he stabbed him some before he confined him to the trailer. We don't know that for sure, but we do know that Mr. Miller perceived it as a fist fight, but the medical examiner testified and that all the stab wounds, the 6 major stab wounds running down the side of his body, were inflicted at a time where Mr. Girard was helpless to resist, or appeared to be helpless to resist, because he was not moving. He's not evading the knife, but he does have defensive wounds.
Now, that's the last thing that the witness sees is the victim down and seemingly dead at that point, and then after Mr. Oyola leaves, Girard's able to get up sort of semi for one last attempt to live? I mean, how is it?
What happens is when Mr. Miller leaves to go get help or go say, come look at this fight, he says that the skinny guy is on top of the bigger guy and getting the best of him. So he leaves. It appears from his testimony that he leaves while the fight is still ongoing. And when I want to say fight, I'm saying, it's really Mr. Girard trying to survive. And when he comes back a few minutes later, and it's not clear how long he was gone, Mr. Oyola is gone. He's managed to turn the trailer around, much to Mr. Miller's astonishment. And Mr. Girard is up on one knee, like Mr. Miller described it as gasping for his last breath, falls down on his face. When the paramedics arrive, he's dead. He's flatlined.
But Mr. Oyola probably first thought he killed him when he was taking him out in the trailer. He didn't. And then he left him, and presumably left him for dead.
Well, again, I think, Mr. McLean might say, we don't know that, but I think, again, you have to use reasonable inferences from the evidence. If you lock a guy in, you incapacitate him to some extent, because we know that, because he's laying down, he's bleeding, he's aspirating blood. You capacitate him, you're taking him out to the Tram Road, out to a logging road off of Tram Road in Jefferson County. What's the logical inference? You're taking it, you think he's dead, he's taking to dump his body. And again, I think that, because there's only one other person out that survived this attack, who didn't testify, we have to take reasonable inferences. And the reasonable inference is that he believed Mr. Girard was dead. He took him out to dump his body, and lo and behold, he hears the struggle and realizes, oh my gosh, he's not dead. He hits the brakes, and the reason why I say that's supported is, and the prosecutor argued this at trial, was there's a blood spot on the trailer, looks like sort of round, looks like somebody hit his head, so like got slammed. They're driving, he hits the brakes, and someone who is injured loses his balance and falls forward. And so then he approaches the trailer, and we know that shortly thereafter, Mr. Girard is dead. And it's a reasonable inference that Mr. Oyola armed himself, went into the trailer, attacked him further, and was successful in killing him. And Mr. Girard fought for his life, and that's where the HAC comes in, especially when we've got a bang on the head, we've got him waking up, it's reasonable that he's terrified, he's in fear for his life, he's trying to break down that door, he can't do it, and then Mr. Oyola comes and stabs him 6 times, according to the medical examiner, along this, I think it was 6 times along the side of his body, and that was the serious wounds. One stab wound went into his kidney 7 inches, at a time where he is down, in a down position and helpless to resist, and that's in the medical examiner's testimony. And the only thing, and Justice Lewis, before I forget it, also in Volume 1 of the trial record is the defense memorandum of, and if you look at the defense memorandum, they kind of smush together a bit the mitigating circumstances somewhat, and I know this court is concerned about the trial court's order is not as detailed as you might like it to be, but you can see where he considered Dr. Dorico's testimony. I mean, he found in non-statutory mitigation he has schizoaffective disorder, he has a history of drug and alcohol abuse, he has a history of child abuse, he has a history of mental illness. So it's clear that he fully considered it, and if you look at the defense memorandum, you'll see that the trial judge considered every mitigator suggested by the defense counsel.
But isn't there a Campbell error in the non-statutory mitigation? I mean, I haven't seen something like this in quite a while, and that is where several things, I mean, maybe it is poor advocacy on the defense lawyer that just,
I'm not going to say that, Your Honor.
No, I know you don't want to say that, and we want to make sure this is evaluated, but it doesn't give us any ability to, on this non-statutory mitigator, to understand whether these were considered separately. I mean, an abusive childhood is different from history of drug abuse, which is different from apparently documented schizoaffective disorder, on which he was. But they're all just put together and for some reason given slight weight, and we have no idea why they're given slight weight.
I think that...
I mean, doesn't this at least have to go back for reevaluation of the non-statutory mitigation under Campbell?
I think, certainly I think the trial judge's order could have been more thorough.
Well, that's very kind of you to say. But it's, you know, against this, what we are used to looking at for the last many years, I just don't know how can I give credence to an evaluation that just simply says I'm giving it slight weight? I mean, based on what?
I understand, Your Honor. I mean, if you find a Campbell error, and I think that in this case it would be harmless error because the judge would still find slight weight. But the only remedy for that is sending it back to the judge for reevaluation on a new penalty phase. Correct. It's only sending it back to now retired Judge Smith. But I think that if you look at the fact is that the evidence supports that these mitigators, you know, weren't mitigators. I mean, this was a 37-year-old defendant. You know, he had that the trial judge certainly could have given them slight weight. I think what we have to understand is that when you look at, you know, his mental condition, not only the fact that the evidence is contrary to what he told Dr. Derko, but here's a 37-year-old man who's been gainfully employed with the victim for a period of time. He's the foreman. He is given responsibility. He's using the debit card properly when he's supposed to.
What was the period of time he worked for the?
He told Dr. Derko that he worked for over 2 years, but I believe I believe that that's probably closer to 8 months. But it's not perfectly clear in the record.
Had he before that had a history of steady employment?
He said, all I know is what he told Dr. Derko is that he had worked he'd steadily worked when he was not in prison. So when he was out, he had steady employment. Where he worked prior to Mr. Gerard, I do not know. So I think when you look at...
But I guess the point is that his mental, what you're saying is that his mental illness did not prevent him from, when he wasn't he wasn't in prison for several years, from being able to lead a productive life and lead
right.
Within the confines of normalcy, be a normally employed person.
Exactly. He worked. He had a responsible position. And it's not like, you know, he's just, and when I say just, I don't mean to diminish that at all, but he's not a pure employee. He is a foreman. He's someone who's Mr. Gerard has entrusted with responsibility. He's worked in that capacity. He's got, you know, there was no evidence presented, you know, that he had a hair trigger temper, you know, and that he was busting guys up on the weekend. So this notion that, you know, he can't control his behavior and it's his capacity to conform his behavior to the requirements of law sometimes on this one day, I think the trial judge, you know, properly rejected it, especially since both in his report, which is in volume 1 of the record, and on the stand, Dr. Derko did not testify that the statutory mitigator was met.
Was it only the brother who testified about the defendant's home life? I'm trying to figure out what do we have in the record that supports even the minimal mitigation that the trial judge found here.
His brother testified at the penalty phase, but also in the record in volume 1, which was attached to the defendant's sentencing memorandum, was interview by the defense investigator of Mr. Oyola's parents, and both of them were elderly and unable to come to trial.
And do we have any indication that the trial judge actually evaluated those interviews?
He found the abusive childhood, and let me...
But as I said, the brother's testimony talks about the abusive childhood, but since we don't have any detail, it's hard to tell.
And the parent, the mom, testified that she had been treated, you know, for her nerves, and she thought it might be schizophrenia. But he found, the trial judge found both a history of abusive, abusive home life as a child, and his abusive childhood created a cycle of violence. And his mom talked about, and I don't recall whether his brother did, but I know his mom talked about gangs and his father talked about gangs. You know, he grew up in Philadelphia. He was born in New Jersey and grew up in Philadelphia, about the gangs and the violence. So the trial court did find two separate
the brother, I believe,
mitigators.
also testified about physical abuse and violence.
Yes, and all the kids left home between age 14 and 16, and whether that was attributable solely to the mom's excessive use of punishment, I don't know. But I do know that there is certainly evidence that his mother had a history of mental illness, and the trial judge found specifically in non-statutory mitigation that the defendant's family has a history of mental illness. His father was a drinker, but it wasn't alleged his father was violent when he was drunk. But his father was clearly, probably an alcoholic, and that again the trial judge found that abusive childhood created a cycle of violence, abusive home life as a child. The defendant himself had a history of drug abuse, and that was also testified to by the brother, and I think Dr. DeRico as well, and as well as the family history. And he did find in non-statutory mitigation that the defendant did have schizoaffective disorder, bipolar type, and that the defendant has a mental disorder. So I think when you look at, it's not a matter of the trial court failed to consider the evidence presented. He clearly did. He may have failed to explain it well enough, but it's the state's position that it's clear from his sentencing order that he considered it. If this court has no other questions, then the state would respectfully ask that you affirm Mr. Oyola's conviction and sentence to death.
Just have one further comment on the trial judge's order regarding the statutory mitigating circumstance. I mean, the analysis here is we have an unrebutted expert testimony. I know we had issues about whether he actually addressed it. The prosecutor felt that he did. In closing argument, he so told the jury. Once that occurs, this court's case law said that is sufficient to establish a mitigator. And then the question becomes whether the trial judge is going to be able to ignore that expert testimony regarding the mitigator, and he has to establish and expressly evaluate the evidence, which didn't occur here, to show that there is substantial competent evidence as a basis to reject the expert's testimony. That wasn't done. That's an inadequacy in the order that I don't think we can overlook.
Do you have a case where we overturned a trial court's rejection of that mitigator where the expert had failed to testify to expressly that there was substantial impairment? I think that question was asked earlier, but I just want to make sure.
I'm not sure I follow the question yet.
Well, do you have a case that supports your position that you're arguing here, where we have overturned the trial court's rejection,
where the expert did not say it was substantially impaired specifically?
Yes.
I don't know that I have a case to offer you on that. I'm saying the testimony here, in essence, that's what he testified to. That's my position here. That even though he did not use the word,
but we look at the transcript, it seems a little equivocal.
It seems a little equivocal. That's not the in context. That's not the way the prosecutor viewed it when he talked to the jury.
Sometimes prosecutors can miss the boat on a variety of things.
I agree that this court can't evaluate whether there was the testimony of the expert themselves established it was sufficient to establish it. Again, I'm asserting that it was established, and if that's the case, then we've got to have an evaluation of it in the record as to why it was rebutted, and that did not occur. Campbell violations, I think, present a particular problem when this court starts to review harmless error in a case as well. When you don't have an order to review, you're necessarily having to speculate what was the judge's reasoning in rejecting or evaluating
mitigation. But you agree that the remedy, if we were to find that, would be to remand to the judge for a reevaluation. It wouldn't give a new penalty phase.
I agree. I agree. I'm just suggesting that for this court's review, that at the very least it should be remanded to allow the judge to do a proper evaluation. I'm not sure without that whether this court really has a basis to do an effective harmless error analysis regarding the sentence. That's all I have.
We thank you both for your arguments. The court will now stand in recess for 10 minutes.
All right.
This yours? Court will now take up the third case on the docket, Hall versus the State of Florida.
May it please the Court, my name is Jim Walchack, Assistant Public Defender from Daytona Beach. Along with Megan Collins, who wrote the brief, we represent Enoch Hall in this direct appeal from first-degree murder and a resultant sentence of death. We would like to focus this morning on issues 3 and 5 from the brief, dealing with the extensive, highly emotional testimony that was presented of the prior violent felonies for the aggravating circumstance and the impropriety of the death sentence. Very brief statement of facts regarding these issues. In 2008, while the defendant was in prison for 2 sexual batteries that were committed some 15 or 16 years earlier, he was working in the Pride machine shop along with approximately 70 other inmates that also worked in that area. After taking 4 pills given to him by a fellow inmate, the defendant lagged behind after his work shift to search for additional pills that were hidden there by that inmate. When he was discovered by corrections officer Donna Fitzgerald, the defendant freaked out and stabbed her repeatedly with a shank which he found at the scene. When he was apprehended by
we really don't know. I mean, we don't know he found the shank at the scene. Are you saying
the only testimony there was regarding it was from the defendant, where he indicated that he found it at the scene. There was testimony from another corrections officer that he had seen in the course of his career some 1,000 machined shanks from a facility such as Pride. So it certainly wasn't uncommon for that to occur, and we do not know that the defendant made it, and there was no testimony whatsoever as to that.
Isn't that a prohibited item? They're not supposed to have shanks.
That's correct, Your Honor.
Well, isn't there a pretty strong inference that people don't just leave them sitting about?
There were pills hidden by this other inmate, Prince, and there was testimony the defendant found it where the pills were. So it could entirely be that this other inmate had it hidden there for his protection or for whatever.
You would, I mean, just so to make sure, just let's say we have questions on the CCP aggravator. You would agree, I would hope, that there are 4 other very strong aggravators here.
There are other aggravators, Your Honor, but we submit with regard to that, if I move ahead to that, that the trial judge made the factual finding erroneously in his order that the defendant had carefully pre-planned this as evidenced by his bringing the shank to the scene, his fabricating it, but there's absolutely no testimony of that.
All right, so let's just assume that there is no CCP. Where does that get you in terms of the rest of the aggravators? You already said, guy's serving, he has 2 prior sexual batteries that he's, violent felonies that he's serving life sentences for. There's HAC, and what else do we have? It's a correctional officer.
Correct, Your Honor.
So we have that. I mean, this is a extremely heavily aggravated case, is it not? I mean, I realize you've got to, defend your, or, argue for your client, but
yes, Your Honor,
it's like all the cases, somebody who's already in prison and commits a murder is sort of up there in cases in which the death penalty is probably intended to be imposed.
Well, we would submit that there is mitigation in this case. The defendant had been, when he was 19 years old, had a dispute with his girlfriend, and the girlfriend's mother and mother's boyfriend were police officers, and they told the defendant's father they were going to get the defendant jailed and raped while in prison. There was testimony that from Dr. Kropp, although he may not have been suffering from it at this time, that these prior convictions for sexual abuse were probably caused by post-traumatic stress disorder.
If you're asking, because number 5 is whether it's proportionate, what case do you have, or cases, that would show that this death penalty is not proportionate.
There's the case of Offord that we cited in the brief where this court rejected heinous, atrocious, and cruel in that case, and based on, and CCP, based on the defendant's mental disturbance in the case, this court reweighed the findings, and we would submit that because of the defendant's remorse, which has been found by this court to be substantial in many cases.
Offord involved a very seriously mentally ill individual. I'm not seeing the, you haven't attacked the failure to find, and there was significant statutory mitigation, as I remember in Offord. You're not attacking, you're not saying that there were statutory mitigators that should have been found, are you?
No, Your Honor.
So what we have is, and how old is this, was this defendant at the time of the crime?
I believe he was in his 40s. It's not real clear.
Because he was raped in prison at 19, that this therefore is mitigating, or after having raped 2 other people for killing a correctional officer?
Again, there was testimony that because of that rape that caused him some psychosexual disorders, which in all likelihood caused this violence.
The trial judge in this case didn't even find non-statutory mental mitigation, did he? What did he? Did he?
Well, there was evidence of suicidal attempts and Baker Acts, which he gave some weight, according to the trial court's findings. If I may proceed with the issue number 3, the trial court abused its discretion in allowing the presentation of extensive, highly emotional testimony, thereby focusing the capital jurors' attention on the extreme trauma and suffering of victims of totally collateral crimes committed by the appellant some 16 years previous.
The testimony of the 66-year-old lady, Grace Shelley, that was read to the jury.
That's correct, Your Honor. But
where's the emotion in that?
But just reading that testimony, it shows that it was highly emotional and could inflame the passions of this capital juror. Testimony was.
It's the facts of what he did. You're not. I mean, I don't know a case that says when you're talking. This is the prior. This isn't collateral crime evidence. This wasn't admitted in the guilt phase of this case. This was admitted as evidence of what the nature of the prior crime was, and our case law is ample that the state gets to explain the details of the crime, and as Justice Labarga said, it was done by reading in one case, reading someone's statement.
That's correct, Your Honor, but while this court has approved the presentation of some details of prior violent felonies in order to establish their violent nature, this court has repeatedly warned that such evidence should be brief, straightforward, general, and must not be overly emotional. Duncan, Cox, Finney, and Rhodes cited by us and by the state. Otherwise,
we read one. One witness testimony was read. The other witness, as I understand, never cried or did anything like that on the stand, did she?
Yes, Your Honor. Page 3034, when the defense objected to the prosecutor leading the witness, the court overruled that objection, saying that that it was going to allow the state attorney to lead because of the witness's emotional state, Your Honor. In reading
and what do you interpret that to mean?
That she was being emotional in front of the jury.
What was that?
That's all that was said there.
That was all that was said.
Now let me read, if I may, some of the testimony that was read to the juror, and even though it was read to the juror from the 66-year-old, let me ask you this: take a look around the courtroom and see if you can recognize this person who did this to you in the courtroom. Do I have to? Well, would you do it for us? Where is he? Right over there? Question: I'm not going to tell you where he is, and look and see if you recognize the person. Answer: oh my God, oh, please don't, I don't want to be, please let me go, let me get out of here. Oh my God, that is him. I don't want to look at this ugly. Oh my God, this man, how could he do this to a person? Obviously, even though you're just reading it, highly, highly emotional, highly improper under these cases that say that you should not that the juror's attention would be diverted from the instant crime.
Was there any request to redact anything from the statement?
There was a request to not allow this to be read to the jury.
To not allow,
the court,
if we cross the hurdle that we've already said you can go into some of the detail, my question to you was there any request to limit in some way that one witness's testimony?
There was no specific request for a redaction of specific portions of that, Your Honor.
Yeah, and your argument is that it shouldn't have allowed, is it your argument that it shouldn't have been allowed at all, that the victims did not have a right to testify and the state didn't have a right to call the victims?
In this other court's cases, to answer a prior question, dealing with this aggravating circumstance during the penalty phase, this court has held that these were truly collateral crimes. That's this court's language, not mine. We submit that the defense attorney did object, saying this was highly prejudicial, overly prejudicial, outweighed the probative value of it. This court has said totally unnecessary evidence, such as these highly emotional matters, should not be presented to the jury, and the state risks reversal when it is.
Are you making any argument in this case about how the prosecutor used this evidence in the closing argument?
Yes, Your Honor.
And what's that? Because that to me seems like a better argument than you're trying to say this evidence was not admissible at all. Because as I read the prosecutor's use of this information, it seems the prosecutor sort of interwove the facts of these prior felonies into the actual aggravators that he was trying to demonstrate in this case.
Yes, Your Honor. It's interesting to note during the prosecutor's closing argument in the penalty phase, the prosecutor didn't go into any of these facts, said it was unnecessary, said that we've introduced the judgment and sentence of sexual battery, et cetera. However, the prosecutor did say and used these in support of heinous, atrocious, and cruel, for example. The fear and anxiety and suffering that goes along with knowing you're about to die didn't make a difference to Enoch Hall.
Was there an objection?
There was no objection to that, Your Honor. However, we submit that the introduction of his testimony was the error, and the prosecutor utilized that, and that is the harm that we have here.
So that seems like the trial judge had already said it was admissible. So if you think that it's being improperly used, it certainly seems that that is a point where you should object to how the prosecutor is using it and not just let it go on.
The defense attorney had objected that it was overly prejudicial, and it doesn't appear from the record that the trial court ever reviewed this statement before it was presented. We would submit that this became
Let's go back to that process. Okay, so how it was before the start of the penalty phase? Was there a motion in limine as to the two victims' testimony?
There was an objection, yes, Your Honor.
And the objection, I just want to make sure, was none of they should be excluded.
The objection was it was irrelevant, and the testimony the testimony that would be presented was overly emotional and prejudicial.
And okay, so, but you agree that the state is allowed to put on evidence of the details of a prior violent felony?
Some evidence, but this court has held that where the evidence is unnecessary, whether it is overly emotional.
What do you mean unnecessary? We have said when someone agrees to stipulate to the judgment and conviction, that the state doesn't have to accept the judgment and conviction because the
That's correct. Because the jury should know the violence in order to weigh it.
Okay, so so now, again, it seems incumbent that if something goes too far, and you say what we would appreciate is the redacting of this part of the statement. Now, you said, well, the judge didn't review it first, but someone has to bring up and say, listen, she can say all of this, but when she got into the, oh, my God, do I have to look at him, that should have been kept out.
Well, the judge indicated that the entire testimony would be admitted, and we submit that was a sufficient objection. It became a feature of the penalty phase of the trial. There was actually, the state presented 86 pages of actual testimony during the penalty phase of the trial. 55 of those pages were devoted to this prior violent felony. Of the 31 additional pages of testimony during the state's case in the penalty phase, all but 4 of those pages dealt with the highly emotional, also victim impact. So we submit that this was a feature of the penalty phase here. Here we have the first victim, GS, expressing her horror at having to see the defendant, her fear during the kidnapping, including her reaction at driving past the cemetery plot, and the defendant's indifference to her need for nitroglycerin, and even her dismay at seeing the earrings that she wore during that. I don't want those earrings. Take them away. I don't want to see them. There was highly emotional testimony from the second victim, DD. The judge even indicated that she was being emotional. She included such unnecessary, and again, that's this court's language in these types of cases dealing with the prior violent felony aggravation. It was unnecessary to include the fact she attempted to vomit on herself in order to prevent this rape, and that the sexual assault occurred during her period with the defendant removing the tampon. Highly, highly emotional, overly so, we believe, and this should result, as this court has warned the state time and time again, don't do this, don't take it too far, and they did here, including the argument not for this specific prior violent felony aggravator, but for heinous, atrocious, and cruel. How did he show his indifference? This was to GS, the prior victim. I don't give a damn about your heart. Shut up, bitch. And then they argued this made it heinous, atrocious, and cruel in this capital case, not in the prior crime, but in this capital case.
It just seems to me that those are the kinds of things that the defense attorney should have just, jumped out of his seat. He already had this evidence about these 2 rapes in the record. The trial judge had denied his motion to exclude, and to have the prosecutor use it that way, certainly, well, we'll probably see it at some other time.
We again submit that CCP aggravator had material, factual, erroneous matters in it from the trial judge, and that should be stricken. The mitigating evidence that was presented was the defendant exhibited genuine remorse even before the evidence of the crime had been discovered.
Let me ask you something before I forget it. When we were talking about the CCP aggravator, and you said that the defendant found the shank where the other prisoner had left the drugs, I thought that he had not found the drugs that the other prisoner left.
I miss in the room where he was looking for the drugs, where drugs were ultimately found when the investigators came in.
Okay, so the defendant never found the drugs.
No, Your Honor.
But you're saying in his search for the drugs, he found the shank.
Yes.
And this is based on what?
He gave 3 different statements, and they all conflicted to some extent, but the bottom line, it appeared to be that he discovered the shank shortly before the corrections officer came in. He hid in a closet to attempt to hide from her, and this is different from the cases that the state cites in support of CCP. Those cases, it was clear the defendant was lying in wait to attack and kill the victim. Here, it appears that he was hiding in the closet to avoid detection and didn't want this confrontation.
Well, it seems to me you're making an inference that he probably found the shank while he was looking for the drugs. And isn't there just as great an inference that he had the shank already on his person?
No, his testimony was he found the shank, and there was no testimony whatsoever that he already had that. So that's where the pure speculation comes from, and we submit that you can't use that pure speculation to find this beyond a reasonable doubt.
Okay, well, even if we agree that there's no CCP, as Justice Perriente asked you earlier, where does that leave you? I mean, we have these other...
Well, first of all, it leaves us with an improper jury recommendation in the case because of our other issue that we're arguing, that the judge shouldn't have given great weight to this jury recommendation where it had these...
Because of what?
Because of the improper emotional testimony from the prior violent aggravator. So the jury was presented with that, and that caused their recommendation 12-0 in favor of death. We submit that there was substantial non-statutory mitigation, including genuine remorse. As I said before, this crime was even discovered. The defendant was sobbing and crying out.
So his genuine remorse would outweigh the other aggravators?
Well, that coupled with the fact that he had been raped in jail and had serious mental issues because of it.
That's 20 years earlier?
Yes, Your Honor. The victim's or the defendant's family testified to a great change in this, testified trouble trusting people. He was angry, isolated. All of these factors, Dr. Kropp said, show that he was suffering at that time from post-traumatic stress disorder.
And he'd been in prison for 16 years at that point.
Pardon me?
He had been in prison for 16 years
Yes, Your
at the
Honor.
point of
Yes,
this
Your Honor.
murder. And do we know what his prison record was like? I mean, did he have a history of fighting in prison or whatever?
There's no testimony to that, Your Honor, other than the fact that several inmates testified he was a very hard worker in the Pride facility.
So the 16, that's all of a sudden.
There are records that he was suffering from schizophrenia, possible psychosexual disorder as well. Those are from the DOC records. There was also evidence in the DOC records regarding his explaining this prior rape while in jail. The fact that the defendant had attempted suicide and been Baker acted twice.
How long ago was that?
That was obviously before his imprisonment, Your Honor. We submit that the improper influence of the jury of this highly emotional testimony tainted their jury recommendation, and we ask that this court reverse and remand for a new penalty phase. Thank you.
May it please the court, I'm Ken Nunnally. I represent the state of Florida. Justice Quince, let me start with your question about his prison history. The testimony was at volume 6, record page 762, that this man had been under no medication for at least 13 years prior to the time he murdered Officer Fitzgerald. The defendant, by the testimony of, I believe, his own expert, again, volume 6, record page 841, is that this man is not psychotic and that he currently meets the involuntary commitment criteria of the Jimmy Rice Act. The mental mitigation, such as it was in this case, was put on at the Spencer hearing, not before the jury. And the reason for that is obvious. We don't have to really wait to 3851 to figure out that trial counsel did not want to put before the jury information that this man, who has previously been convicted of multiple rapes, is properly diagnosed as suffering from a cognitive disorder not otherwise specified and from coercive paraphilia disorder. That is the mental state mitigation that came in at the penalty phase. Or, I'm sorry, at the Spencer hearing. These drugs that the defendant was so diligently searching for are ibuprofen, which is known, I'm sure, to all of us, and another drug, trade named Tegretol, I cannot pronounce the chemical name for it, that, according to the testimony, is an anti-epileptic drug that has no real psychiatric side effects. The defense expert, Dr. Buffington, who is a pharmacologist, not a psychologist or a psychiatrist, testified that, in his opinion, Tegretol could, quote, unmask, close quote, underlying psychiatric conditions. However, the problem with that in this case, as the rest of the experts testified, is that there's nothing there to unmask, which leaves us with no statutory mitigation and the defendant's remorse as mitigation. Under these facts, this is a case that beyond doubt cries out for the death penalty. If the death penalty is appropriate, this is that case. This man lay in wait to kill this officer. His ultimate motivation, we do not know. We may find out down the road, we may not. I can't see that far in the future. What we do know is that this inmate had been a Pride inmate for a number of years. He came into the Pride program apparently at Tomoka Correctional, started out as an apprentice welder, worked his way up to a lead welder. He was well familiar with the procedures that go on within the Pride component or part.
Just in terms of the narrative that you've given, and I essentially agree with everything except the laying in wait. When you have a defendant, and you said, well, we don't really know why he would have laid in wait. His explanation is, I freaked out. Now, not freaked out, that doesn't have to be a mental freaking out. I'm here, I'm discovered, and now I'm going to get in trouble. I freaked out. He's seen running down the hall, I mean, basically admitting what he did, and you agree that remorse was properly found. So doesn't this case still, I mean, if my version, which is a little bit closer to the defendant's version, that is, which is he is discovered doing something he shouldn't be doing, and he then does stabs, does everything else, and he has 2 prior life sentences for sexual battery, and it's a corrections officer. Doesn't it cry out just the same way, I guess, as without trying to speculate on CCP? And that's so. I mean, isn't your case just as strong without CCP?
Yes, ma'am, it is. The state doesn't have to have the CCP aggravator to sustain this conviction. But the state's position is that under the facts, that the CCP aggravator was also properly found. The reason I say that is this. This man knows the Pride procedures. The Pride procedures clearly were that as the inmates lined up to check out and go through the metal detector, get patted down, and pull their cards, their time cards, where they get paid, this man knew from years of experience and years of working in Pride that if he didn't check out, that CO was going to come looking for him. This man was back in the welding area, as I understand it, and I have never been out there, and I don't have a real clear picture of the layout of the Pride unit. But as I understand it, he was back in the welding area, which is where he worked, and according to at least one of his statements, when he hears the correctional officer come in, he's hiding back in the shadows, and he has the shank behind his leg.
And he's trying, is his motive he's going to try to escape from prison?
There is some suggestion that was perhaps part of it. There was a suggestion in one of the statements, I believe, that he was going to put on her uniform and go walking out the gate. Now, probably not very realistic, and I don't know that that's a real good theory for him to be floating. But his statements kept changing.
What was his size?
5'8". He's a little bit smaller than me.
And the victim?
She's about 5'5". 5'5", 155. That's not according to the medical. 5'4.5", I believe. 5'5", according to the medical.
You have an extra large uniform?
I don't know what size the BDUs were, Judge. But I went, because I read that, I went back and actually pulled it up on the DOC webpage to see, hey, is this realistic or not? And, okay, maybe it is kind of. But was the motivation of sexual assault? It may have been. There is we know the officer was found nude from the waist down. We know she was moved from where she was killed by being put on a push cart of some sort to another area where she was transferred to another push cart.
Did the state charge him with attempted sexual battery?
No, ma'am.
So where does that fit? Did the state argue?
No. There was no mention of a sexual motive behind this crime during this trial. Like I say, we may find out down the road. We may not.
I'd like to ask you about, with the use of the HAC, would you agree that the unobjected to comments where the prosecutor says that as basis for the HAC, look what he put these other victims to would be an improper use of those victims' the victim's testimony?
That is one of those things that I wish she had not done.
I'm just asking, is it improper? It doesn't mean it's fundamental error. It was unobjected to.
Exactly. It's unobjected to. It's not fundamental error.
You cannot use the prior violent felony to support HAC.
No, you can't. And the statements taken in context, I refer the court to them. The statements speak for themselves. I'm not going to argue against them.
And when we talk about this, we've got what you say. If there's any case it's going to be a death penalty case, this is going to be one. You've got 2 prior violent felonies. You've got at least 4 good aggravators. Why do prosecutors go and overtry something that is clearly erroneous? And that's just a rhetorical question. I can't answer that one, Justice Pariente. I really can't. I suspect a slip of the tongue, one of those things, like I say, I wish hadn't happened so y'all wouldn't be asking me these questions. But at the end of the day, it doesn't make any difference at all. This man got the death sentence that he received because of what he did, not because of anything the prosecutor said or didn't say. This is a death case. Actually, Justice Pariente, there were 3 prior sexual offenses, and there's a 4th out there also that they didn't really do anything with. 2 victims testified. The 3rd victim did not. Man was serving 2 life sentences plus 40 years and something else. We have said that prior violent felonies, that the victims can testify, but we also have said that they can't be over-emotional. Where's the line drawn, and was it observed in this case? Or because I am concerned about that's part of the statement, which wasn't highlighted, to me at least, about, where she starts to talk about, I don't want to look at him, or, that seems like it's not necessary details of the crime. So where's the line, and were there parts that may have crossed the line in this case?
Did this case cross the line?
No, parts of the testimony that probably were inappropriate, such as the one that Mr. Walchack pointed out.
If it had been live testimony, maybe. As it was, this is a cold record read. As far as we know, we don't know to the contrary, I'll put it that way, unemotionally, in a detached manner.
So it would have been easy if it had been requested for one part to have been requested to be excluded, but that wasn't done. There wasn't a request to just exclude part of it.
The defense went all or nothing.
And there's no case that we have that would say that they can't put on any detail, the state can't put on any details of a prior, none.
No, the law is real clear. The state gets to prove up the details of the priors.
If the prior was an innocent not a robbery innocent, but an unemotional robbery, they might want to emphasize that's not not all prior violent felonies are equal. This is a pretty, other than murdering somebody previously, violently raping 2 victims is up there with the very
It's pretty much close. It's pretty close to the top. And keep in mind now too that both of these prior offenses were not 92nd armed robberies. These were lengthy abductions that, quite candidly, it took some time to describe them. And the defendant it's the fruits of the defendant's handiwork. He committed these offenses, and the jury needs to know what they were, and the state is entitled to prove them up. If the defense had chosen to step back from their all-or-nothing approach and ask for redaction or limiting or something of that nature, then we would have something else, I suppose, to talk about, depending upon what happened and how the trial court resolved those issues. But that's not what happened here. And that's really about all I can say to that. While these were graphic descriptions, these were graphic crimes. And the corollary would be you take your victim as you find them, and the state takes the crimes as we find them in this particular case, and we're entitled to put it on. And there was no error under Florida law in doing so. I would suggest in closing that the trial judge properly found all of the aggravating factors that were applied. I would submit that the coldness aggravator is equally applicable here. I've addressed that fully in the state's brief, and I don't see the need to reiterate that again, other than to state that the defendant knew Officer Fitzgerald. He knew Officer Fitzgerald was going to be the person coming to find him when he did not check out of the Pride facility. As the trial court found, there are a number of other factors that support the coldness aggravator. The trial court, the state's position was correct in finding them. If the court disagrees, even without the coldness aggravator, death is still the proper sentence. There is no error at all. Any error with the coldness aggravator is harmless beyond a reasonable doubt, and we would ask that the conviction and sentence be affirmed.
May it please the court, just briefly to answer the question, where should this court draw the line in testimony regarding the prior violent felony aggravator? I refer this court to its own language in two cases, Rhodes and Finney. The line must be drawn when that testimony is not relevant, gives or the prejudicial value outweighs the probative value. In this case, they said the testimony was irrelevant and highly prejudicial to Rhodes' case. The information presented to the jury did not directly relate to the crime for which Rhodes was on trial, but instead described the physical and emotional trauma and suffering of a victim of a totally collateral crime committed by the appellant. That's exactly what happened here. And in Finney, however, while recognizing that this testimony of some nature can be admissible, however, the collateral offense need not be retried.
What was the crime in the first case?
That was one to which he had pled, so there was no trial testimony, but they introduced a tape-recorded statement from the victim.
Of what crime?
Regarding battery with a deadly weapon and attempted robbery.
The thing that seems to hit at the heart here, I'm not sure that there's any delicate way to describe this event. This, as one reads it, the brutal rape and what these people went through, I mean, how does one sanitize what actually happened when it's non-sanitizable?
This court has said in other cases, however, this was direct testimony. It was direct. It was general testimony. It wasn't overly emotional. This clearly was over emotional.
But I'm saying that just the nature of the event, the nature of the crime itself, is highly, highly to the nth degree of an emotional nature for a female.
Yes, it was emotional, but there was no need for the testimony of driving past the grave site and her being placed in fear because she saw her grave site and said, "Oh my God, is this going to be it?" Her testimony regarding having to identify him in court.
But I guess there we go back to that was the transcript. So the proper way to handle that would be to say, Your Honor, we don't think any of this should come in, but if it is, please excise this portion.
Now, the ruling by the court was this was admissible, and the defense attorney let it go at that.
The judge didn't even read it, so the only way to make the judge aware of it is to say, but this is the part we would ask be deleted.
We submit that this was overly emotional, overly prejudicial, and the state should have excised these portions in order to prevent this error from occurring. Again,
that would be an interesting rule of law.
Did you say the state should do that, or that there was no way that you could excise it? Did you say the state should do it?
The state should have realized that it was overly emotional under these cases, Rhodes, Finney, Duncan, that we cited, and they risk error by introducing these.
There was no obligation on the defense attorney's part, under your theory, to say, Judge, we don't think this should come in, but if you're going to let it come in, Judge, These are the parts that are truly prejudicial, and we ask that you at least redact those portions.
The defense, I can only assume, felt that the entire testimony was overly prejudicial and that it outweighed any probative value. It was unnecessary.
So you would say that the rule of law would be that if somebody has committed 2 prior brutal rapes for which he is serving life sentences, that the fact, the more egregious the prior crime, the less latitude the state has to explain the crime to the jury? Is that...
No,
Your
Honor.
Maybe it goes back, it's what Justice Lewis is saying.
I think there needs to be a line drawn, as this court has said. Particularly true where the highly prejudicial evidence is unnecessary, where the evidence is likely to cause the jury to feel overly sympathetic towards the prior victim, which is exactly what happened here. We ask this court to reverse and remand for a new penalty phase. Thank you.
We thank you both for your arguments. We now go to the 4th case on today's docket, the last case, which is Kavaleski versus the state of Florida.
May it please the court, my name is Tatiana Ostapov, Assistant Public Defender in West Palm Beach, on behalf of appellant Anthony Kavaleski, who was convicted after his 2nd trial.
Could you speak up a little bit?
Oh, I'm sorry. Can I fix it? Yes, he was convicted after his 2nd trial. The issue, you still can't hear?
No, now we can hear. I'm just...
Okay. The issue in this case is whether the state statute, section 918.16, absolves the trial court from the obligation or from any duty at all to inquire into the circumstances surrounding whether a trial should be partially closed or closed.
The first trial, the basis for the reversal of the first trial was that during the testimony of the victim, who was then 16, that there was a partial closure of the courtroom?
That's right.
So I guess what I'm trying to find out is, so what changed between the first trial that caused this to be reversible error and this trial that the 4th District thought it wasn't reversible error?
The first trial statute that was in effect only provided for closure where the victim was
so the
less than
statute
16.
changed.
Right.
Okay,
the second trial...
I was trying to find that out. So it was that subsection 2 was added.
Yes.
After the first trial.
Okay,
and that helps me because I was maybe searching and I just didn't see that. Okay. My other question, and it just sort of goes to the importance of the role of the public trial, but then, and I know if it's properly objected to and there's an improper closure, it's a structural error. But in this case, when the state invoked the statute and the judge granted the partial closure, it was who had been in the courtroom and who was it just that an assistant state attorney was asked to leave?
No, it's not really clear who was in the courtroom. In this case, the court, there obviously were a lot of people in the courtroom before the court was the trial was closed.
I read in the brief that they were saying that the only person that left was an assistant state attorney.
No, not in this. That's not the indications.
I mean, the only reason, because if you look at Alonzo, they make a big point of explaining that the defendants had no relatives, that it was his minister that had to leave, his cousin, and you may say it doesn't really matter who leaves or who stays in, it's still a partial closure. But to me, it kind of, so you're saying the record's not clear about who came from the court, who was cleared from the courtroom?
What the trial judge did when the objection first was made, when the issue first came up, the trial judge asked the state, are you requesting closure? And the state said yes. So there's not even any indication in this case that the victim actually directly asked for the for the trial to be closed. The judge then basically is on the train because he's obviously read the statute, and the statute makes it mandatory. He reads the statute as making it mandatory that if the request is made, the trial has to be closed. And the trial judge then, the defendant makes his objection.
And what was his, and that's the other thing is, his objection is, I object for the record.
Yeah.
What does that mean?
Well, it means, Judge, let me interrupt. We object, and the judge just keeps on going. The judge recognizes that as an objection because later on when he does get ready to exclude the public from the trial, he says under 918.1, this is at page 703 of the transcript, over defense objection, the statute is quite clear. So the judge had decided, he'd read the statute, it was mandatory, he knew what his duty was, and he was going to do it.
Do you agree that the statute is mandatory?
No, well, the statute reads as though it, yes, the statute,
shall clear
it does
the
say
courtroom.
that. What our position is that, and I think it's supported, well supported by the case law, is that even though the statute says there's a mandatory duty, the court, before it can exercise that, has to conduct an inquiry.
Well, is the inquiry the first, so the first question is whether Waller applies to partial closures, correct? That's the first issue that we would have to confront?
I think the first question is whether
if it doesn't apply to partial closures, then this, then as far as the statute is concerned, and there's no issue raised as the constitutionality of the statute, it is it's a limited closure in terms of there are many designees that are to remain in the courtroom for the testimony, and so unless the constitutionality is being challenged, it seems to me that there is not much more of an inquiry. Am I missing something?
I think so.
Thank you.
You're welcome. The first question is, can a statute obviate the requirement for any inquiry whatsoever?
Therefore, the first question is, does Waller apply to partial closures?
Well, okay. Well, see, and that's why it's real. I think it is important to get the order of the questions right, because if the statute can obviate the requirement for an inquiry, then the statute's valid. The case law is, and from the Supreme Court has consistently held a statute cannot, by itself, justify closing the courtroom.
Well, so then shouldn't there have been a motion to declare the statute unconstitutional?
No, because, and the Florida cases make it pretty clear, the second and the third DCA both have held that procedure is incorrect. They both held the statute is constitutional on its face, but as applied, if you apply it without conducting the inquiry, that's where the problem arises, and that's what makes it unconstitutional. And I think that's the correct analysis. I mean, on its face, that statute's fine, but you have to still, to make it constitutional in its application, you still have to conduct the inquiry. And if I can, as to the partial closure, whether it's partial or impartial, first of all, well,
wait a minute before you move beyond that point, though. So at the point when the trial judge says that under this statute, I'm going to, exclude certain people from the courtroom during this one witness's testimony, the defense had no obligation further to say anything.
Well, I think at that point the judge had already made up his mind, so I don't know that there was anything further it could say. Certainly the court, because of the nature of the way this case came up, the court had the fourth DCA decision where the district court discussed the requirement of conducting an inquiry. So, I mean, it wasn't like this was a completely blank slate that we were writing on. And I think also, the way that this all went down, the court is, the defense attorney is interrupting the judge when he does make his objection. The court says, all right, now as far as 918.6, do you all seek to have that invoked? The prosecutor says yes. The court says, all right. Mr. Stone, the defense attorney, Your Honor. The court now, Mr. Stone, the defense attorney, for the record, we object, Your Honor. The court, okay, I'll sort this out in just a second. Now, when you want him brought in, what do you want to do with his shackles and stuff like that? And then they go through, and that's at page 701 of the transcript. At 703, the court says, just 1 second, I'm going to do this 918. So he's returning now to the 918.16. Now, under 918.16, over defense objection, the statute is quite clear. I'm obligated, if requested, which have been done on the behalf of the victim, to clear the courtroom. And now then he announces to everybody, he gives the list. These are the people that are allowed to stay. Everybody else, you have to leave. And so in other words, what I'm saying is the court had decided, the court recognized that an objection was being made. The court decided, no, whatever happens, the statute controls, and I'm going to go with that.
So what more, really, are you contending that the trial judge should have done?
Well, I think he had to conduct an inquiry. We think he had to conduct a Waller inquiry, which was where the first question is there an overriding state interest? Because we're saying that...
That's not let me just ask you about that one.
Okay.
And that's not provided by the statute?
No, the statute does not say that. The statute just says...
No, I'm saying...
yes.
If you interpret the statute, I mean, the statute seems to be trying to protect the victims of these sexual assaults.
That's right.
Correct? And so that doesn't satisfy, you're saying that does not satisfy the first prong of the Waller test?
No, we don't think it does. Because, and the reason we don't think that the statute, the Clements, which is the DCA case where, the DCA said this statute on its face is sufficient, we don't have to do anything more, no inquiry is required. The first thing that they said was that this legislature has made a finding that sexual battery victims don't have to, whatever happened to them was so traumatic that in every single case, as a matter of law, they do not have to testify in public. And the Supreme Court pretty much more or less specifically said that the statute, the legislature cannot paint with such a broad brush. Because there are situations where the victims might not be troubled by having to testify at all. And they suggest, where their names have already been published or their accounts have already been told on multiple occasions. Maybe a prostitute wouldn't have any...
They would probably be the ones who wouldn't request that the trial judge close the...
Well, except that the way that this statute is, it seems to me, is being handled is the prosecution pretty much on its own in every case requests closure of the trial. So, we don't, in this case, like I said before, we don't even have any indication on the record that the victim himself ever actually requested that the trial be closed.
Well, that would be, but wouldn't that be then a specific, if there is that objection that the statute's not properly invoked because it's not the victim requesting it, that would be the kind of specific objection that should have been made at the time, not after the fact.
The reason that the answer to that is no is because the Supreme Court says that it's the obligation of the state before they get closure to establish that there's an overriding state interest that needs to be protected, and that will be...
I'm talking about whether the statute applies. The statute applies only when the victim requests.
That's right.
And I thought you were saying it's not even clear the victim requested it.
It's not clear, and I think that... Okay, that's another objection that could have been made that was not made.
The problem I have with, and again, I'm not sure where this comes out because you've got two, Alonzo, and they have some pretty good arguments in terms of this, is that if the overriding interest is not protecting the victim of a sexual crime, and it has to be, it's different if it's a 23-year-old victim, he's 23 now, versus a 10-year-old.
Right.
And they're all treated the same. Then it means that if the judge makes a finding in a given case that because, even though the victim requests it, that the victim is now older, or is older, 30 years old, 40 years old, they would be disregarding the statute if they conduct this inquiry and find that they're not going to close the courtroom. So since you say, well, I don't see how it can be the statute can be construed constitutionally with the Waller requirements is, I guess, what I'm saying. I'm just not seeing how that they're compatible. One's mandatory to do it, and the other says you've got to go through 4 factors, and if you don't do those 4 factors, which include other alternatives, you can't close the courtroom.
Right.
So how do you reconcile this statute and Waller?
I think the way that the courts have reconciled it is that they have held the statute is itself not unconstitutional as long as it is applied by the trial court conducting this kind of a hearing, this kind of evaluation. And part of the reason for that is because the right to a public trial is not just personal to the defendant; it's the right of the public to be able to view the trial. And so, it's not just the victim's right either. I mean, it's a broader right, and it covers various parties or various observers to the trial. So, just the state saying that, you know, as a matter of course, we're going to allow a certain class of victims to testify in private is insufficient to satisfy the constitutional requirements. And I mean, in Globe newspapers, U.S. Supreme Court case, they had a statute where it was minor victims who were not required to testify in public. And the court said, we recognize that could very well be a compelling interest. But as compelling as that interest is, it does not justify a mandatory closure rule if it is clear that the circumstances of the public case may affect the significance of the interest.
But isn't there a significant difference between a total closure and a partial closure?
You know what? I don't think that there is, honestly, because, you know, the way that the courts apparently have been saying if any person that is not a party to the case is allowed to stay in the courtroom, including the victim's mother, you know, the victim's victim advocate, that makes it only a partial closure.
What about the press? The press is there, so.
Okay. I don't understand how having a relative of the victim present or an associate of the victim.
But that's not what we're talking about under this statute.
Sort of is. Yes, it is. I mean, that's what defines whether this is a public trial or not. Now, there is the additional factor of the press being allowed, which is a newspaper reporter or a broadcaster being allowed. Whether the press, I don't understand. Again, the press, I don't think, is an adequate proxy or substitute for allowing the public to come in. And one of the reasons for that is because the press doesn't cover every single trial. I mean, the vast majority of trials are not covered, they're not graced by any presence of the press. And in the third DCA cases, they specifically referred in their decision to the fact that there was no press. We don't have any indication.
In this case,
we have no indication that the press was. But we don't know who was present. Honestly, we don't know who was present.
Now, also, Waller requires that it be narrowly tailored. And Waller, I believe, they closed the court for 7 days.
Right.
Here, it was just for the entire trial. But here, it was just for the victim. And it seems to me as if the statute is narrowly tailored as to not to make a broad sweep in terms of closure.
The key person in a trial like this is obviously going to be the victim. And therefore, having nobody see the victim's testimony.
Nobody?
Nobody other than
this is partial, not total.
Yes, other than these limited personnel, but not the public. It's the public's right to see the trial. The press, if that ends up being somebody, if Nancy Grace comes to a trial, she's a broadcaster, if she comes to a trial and then reports what she saw, I mean, is that going to be an adequate substitute for the press? I don't think so. Or for the public, I don't think so. Because just because you have some person from the press there doesn't mean that she's going to convey, he or she is going to convey the demeanor of the witness, you know, what was actually said.
It didn't say one member. It said newspaper reporters or broadcasters, plural.
But if they don't come...
It's not just to Nancy who might have a bias one way or another.
Right. But if the press doesn't come, then nobody's allowed to see it. But how does that protect the public's right? If the defendant's neighbor wants to come...
Isn't it a weighing process whether or not the interest of the underage victim who's less than 16 testifying in a sex case? I mean, are you saying that there's never an instance where this can happen?
I'm exactly saying what you're saying, which is that it is a weighing process, and the trial court has to weigh before it can make the ultimate decision. And that's what the cases say. And just because it's a partial closure doesn't mean that the court is absolved from having to do any inquiry whatsoever. To the contrary. I mean, Douglas v. Wainwright says that what happens in those cases where they held that the partial closure does make a difference is they hold that the standard of that first inquiry is different, that instead of an overriding interest, it's sufficient if the court finds a substantial interest. But
Counsel,
then the court...
You're now down to less than a minute and a half of your total time, so you're well into your rebuttal.
All right, but thank you. But I do have to say that the court... I'm sorry. There has to be a weighing done, and there's a different standard, and the additional factor of whether that remedy is sufficiently tailored, whether there are alternate means, that inquiry still has to be done by the trial court, whether it's a partial closure or a total closure. And in that Maryland case, longest...
Well, it seems that then your interpretation nullifies the statute.
No, I don't think it does. It says that there is an indication that if the victim makes that request, then the court has to conduct that inquiry, and that's what the cases do say. Thank you very much.
Good morning, Catherine McIntyre on behalf of the state of Florida. May it please the court. Your Honors, the trial court's partial closure that was conducted in this case did not violate Kavaleski's right to public trial, where the closure complied completely with Section 918.16 sub 2. A closure under 918.16 sub 2 does not run afoul of the Waller factors, wherein the Waller factors are incorporated and accounted for in creating a narrowly tailored partial closure. Now, before I begin, I wanted to address some questions that were raised before, as far as clarifying the first trial. During the first trial, yes, there was a right to public trial issue. However, the way that it came about was that the victim was 16. The statute protected witnesses under the age of 16. When the trial court conducted the closure under 918.16, there was no objection. However, during the victim's testimony, they asked him his birth date, and at that point it became evident that the victim was no longer 16. Hence, he was no longer protected under 918.16. The defense counsel, everybody had a bench conference, realized he was no longer 16, thus 918.16 was no longer applicable, and the courtroom continued to be closed over objection. That's what happened. That's not what we have here.
When you say the courtroom was closed in the first trial, meaning there was nobody in there other than the defendant and the victim and nobody from the press, nobody...
No, Your Honor, what I mean is that the courtroom was partially closed under 918.16. Therefore,
no, but once they found out that he was 16, so the statute didn't apply.
They did not reopen the courtroom.
But who had been excluded?
During the first trial, I have not read specifically in 1998 who was excluded. However, I do know who was excluded and who was here in this trial, which is what we are today. Who was there? Well, the record is clear that the discussion about the 918.16 closure took place prior to the closure. It was during the jury instructions, a discussion about jury instructions. At that point, the trial court explained a 918.16 closure to clearly a gallery of people and indicated when the victim takes the stand, unless you're on this list, you're going to have to ask to be leaved. The victim goes ahead and takes the stand about 20 pages later. And at that point, a bench conference is conducted, and the trial court asked the state attorney to ask one other state attorney to leave. It is clear that he's looking at who's in the courtroom. And then, at that point, they specifically identify that there's a news reporter from the Press Journal in the gallery. So in as much as there's an indication that it's not clear whether the press was there, the press was there. Notwithstanding, and even further, during the victim's testimony, there was a break. Coming back from the break, the trial counsel brought it to the court's attention trial counsel for Kavaleski brought it to the court's attention that there was one person that he wanted in the courtroom, and that was a gentleman identified as a friend of Cactus Jack's. And trial court said, you want him, you got him, and let him in. So in as much as he's indicating, oh, there's somebody that now he's indicating on appeal, my right to public trial was violated, where? We followed the statute specifically as worded, and when you brought something to our attention, we let him in. There was no violation of right to public trial here.
What is the difference, just I want to make sure from your point of view, between a partial closure and a total closure?
Your Honor, the case law is pretty clear. A total closure, which is Globe, Press Enterprise, all those cases, a total closure is only essential personnel are allowed to stay.
So if it's, and it's not, it doesn't mean the whole trial, it's at any point, whether it's voir dire, it could be a witness's testimony, if only essential personnel are allowed to stay, that's a total closure.
That is a total closure,
part.
yes. If spectators are provided for, it is now a partial closure. This statute...
So that's why this is a partial closure, because there's press and there's designated people, so that's why it's partial.
Your Honor, it's a partial closure because in addition to press and partial people, it provides for victims, immediate family victims, advocates, immediate family members of both the defendant and of the victim, newspaper reporters, broadcasters, an exhaustive list of people are allowed to stay during the limit, and the closure can only be limited towards the victim's testimony.
Well, again, as was said, I mean, in a sexual battery trial, oftentimes the victim's testimony is the main testimony, although I think here we have pretty important testimony from the ex-wife as well. But as far as the state's position as to whether Waller and its progeny applies to partial closures, or if there wasn't a statute here and the judge on his or her own did the exact same thing without making any inquiry, would there be a problem?
Your Honor, it is our position that unless the closure is under specifically 91816, Waller applies. The only difference is that if it's a partial closure, we may need a substantial interest versus a compelling interest.
So that is helpful. So if it was another case, whatever, a murder case, and you have a victim somebody wants to protect, the judge would have to go through the Waller inquiry.
Hence the error in the first, during the first trial.
Why is it that if Waller is constitutionally based,
yes,
how can the legislature trump the Constitution? In other words, unless the statute follows the rules for a partial closure, how do we avoid that inquiry not first being made before the statute is then applied?
Okay, Your Honor. Yes, I do understand where you're coming from. Your concerns about perhaps judicial discretion being taken away by
Well, you already said that if this wasn't for the statute, they would have to comply with the four-pronged test, but instead of compelling, it would be substantial interest.
Yes.
And that is not a rule of the common law or rule coming out of good policy. It's a rule coming out of the Constitution of the United States.
Okay, and I agree, Justice Priente. However, the issue here is that...
So I just don't understand how the statute can override the Constitution.
91816, if you put it hands in hand with Waller, put it right next to each other, it doesn't overrule or it doesn't try to void Waller in any way, shape, or form. It incorporates, it embraces Waller.
Well, does it make a difference if you have a 10-year-old victim who, and whose guardian or parent has requested this closure on the victim's behalf, or a 40-year-old that wants the world to know what happened, what happened to him or her? I mean, does the judge's discretion get changed depending on the age of the victim?
No, Your Honor. Well, in the second situation in where the older victim wants the world to know, if the victim wants the world to know, They will not require 9/18/16.
So is there any issue here that the victim requested this closure?
No, Your Honor. There is no. I clearly recall a conversation during the trial wherein the state was asked whether they were going to invoke, and they indicated that they would discuss it the next day, that they would talk about it the next day. I reviewed the trial transcripts real quick. I only have the substantive trial. If I may be able to supplement with that record site if I find it. However, if it's not in the trial transcript, conversations between victims and prosecutors don't always happen on the record, especially when you're preparing your witness. So the victim may necessarily have asked the prosecutor that they would like their privacy interests protected. And I would submit to this court that this victim was especially hesitant. He had to be arrested and brought to the court in order for his testimony. He said he didn't want to be there. So I would submit that this victim...
Did the prosecutor actually state on the record that the victim wanted?
Yeah, that they would be requesting it pursuant to the statute, thus the inference was that the victim had requested it. However,
okay, so just to make sure, so it's an inference, but, and again, this wasn't specifically raised that the statute's not applicable, so
It was not raised that we don't believe that the victim asked for it. It wasn't raised. The only thing that was said was 4 words, I object, for the record. That's 5 words. That's it.
Well, we do know now. I mean, I agree as to the specific issue of the victim, but when the judge says, I understand your objection, and subject to your objection, I'm overruling it, there's no question that they're talking about whether the statute should be invoked or not. I mean, so the judge was determined to apply the statute. At that time, didn't Alonzo and the case from you had Clemens, you already had a conflict between the districts. Had the 4th district weighed in on the issue at the time of this second trial?
No, Your Honor. At that point, the only time that it had thought about the issue was in the context of when 9/18/16 was no longer applicable during the first trial.
So the judge had either Clemens to follow or Alonzo?
Your Honor, however, yes, the judge had either Clemens to follow or Alonzo. In our position, Clemens was the appropriate one. However, Your Honor, I'd also like to discuss Alonzo for a second, how Alonzo is completely distinguishable than what we have here. In Alonzo, the trial counsel had the discussion with the trial court during about 9/18/16. He objected and specifically indicated that it would violate his right to public trial. Later on, when the statute was actually invoked prior to the victim's testimony, he objected again, indicating his uncle was being asked to leave. So here what we have is he objected when the discussion was being had during jury instructions, and I believe 20 to 40 pages later, 20 pages later, when the closure actually took place, the trial counsel stood silent. I would submit to this court that at the very least, once you invoke the case and you're about to be harmed, that's when it's incumbent upon you to jump up and say, my uncle's being asked to leave. I asked if you could please consider him to stay. Things of that sort. Here we don't have what happened in Alonzo. We don't have a specific harm, a specific
prejudice. Well, we know though, but for the statute, that wouldn't be required. In other words, if you object and say I object to this closure, they're not required to show how it harmed them. It's a structural error.
I disagree with that, Your Honor, in as much as that he could have objected to the closure. He may not have necessarily objected to the constitutionality of the closure as much as he have objected to. I didn't see a conversation between the victim and the prosecutor. I don't think that the victim asked for this, or as what happened in all the second DCA cases, they went outside the statute and excluded everybody, or excluded people that were specifically included in the statute. At that point, you have an actual basis. But as far as to go ahead and speculate, well, obviously by objecting, they're objecting to the right to the fact that there is no hearing, that the factors haven't been considered, and this is a violation of my right to public trial. There was no kind of objection to the form. There was no constitutionality challenge. There was nothing that was said other than I object for the record. And I think that we don't want to take that huge leap into thinking that that's what they were trying to do.
What were they trying? What would the objection, other than saying that the statute should not apply? I mean, what other What other basis for the objection could there be? I mean, I agree with you that there's no issue about the victim not invoking it. But it's just, and I'm concerned that if we decide this case on the basis this was not a proper objection, but Alonzo was, we're just going to get us into a post-conviction status, because if a proper objection should have then required the inquiry, then we're back to, aren't we back to where we started? But I guess what I was asking you, though, was that once an objection is made, assume it's a proper objection, that you don't have to show on appeal that the error was, whether it was harmful or it's a structural error.
Assuming that we find a violation of the right to public trial. And that's assuming that we have a right to public trial. And, Your Honor, just to go ahead and answer your question as far as should this come back as a 3850 or what happens if it comes back at a 3850, he still has to show prejudice. He cannot show prejudice. The one person he wanted there stayed. He didn't object to anybody else being asked to leave. Your Honor, we do not want to go too far away from what the right to public trial was created for, what the right to public trial honors, and that is for the protection of the defendant, or basically anybody accused of a crime, for the innocent, that they not be unjustly prosecuted, and for the guilty, that they may be afforded a fair trial. Nothing that the trial court did violated this right. So we ask you to, unless there's any other questions from this court, we would ask that you affirm the fourth DCA's opinion below and affirm Mr. Kavaleski's convictions. Thank you.
Minutes, just to very brief.
I will give you 1 additional minute.
Well, okay. The right to public trial is not just the defendant's. In Pressa Enterprise, the United States Supreme Court addressed a situation where the defendant requested, and the state requested, that the trial be closed because of a danger of unfair publicity, and the Supreme Court said that that was not valid. That was pursuant to a statute. The Supreme Court says you can't do that because the public has a right to be present, and it's not just personal to the defendant. So everything that was just said, I think, is really not well-founded. And the second thing that I want to say is that in the fourth DCA opinion reversing the first conviction, the court noted in a footnote that Pritchett v. State, which was, I think it was the second DCA case, had already been decided and had held that Waller inquiry was required in cases even of partial closure. So this issue was out there at the time that the second trial took place. Thank you very much, and thank you for your indulgence.
We thank you both for your arguments. That's the last case today, so the court will now stand adjourned. All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.